I had to apply my mind, so therefore it took a few days. In view of the above, I am of the considered view that no ground is made out for interference with the impugn orders as such. However, considering the 4 years old child of the petitioner is admittedly diagnosed with the disease which requires regular medical treatment and therapy, it would be desirable in the interest of the child to have the presence of both the parents for such care. The respondent authorities are directed to reconsider the grievance of the petitioner for joint posting at a place having the medical and educational facilities for the best interest of the child vis-a-vis administrative exigency. We don't find any ground to interfere with the this
Oh,
thing,
sure.
but then
That is
considering the thing,
Yes.
not necessarily Guwahati or somewhere else.
Oh, sure.
I mean,
Oh, sure.
you have to balance both. Petition dispose of in terms of.
Oblige Lordship.
There was a third lordship.
Records to be returned.
I'll collect it. Sir.
Yes, I have records to be returned. Correction. Something that. Yes,
May I please, Your Lordship? Lordship, I beg to mention the item number 2, Your Lordship,
yes.
of the daily list. Lordship, I am for the petitioner.
Mm.
The learned counsel for the petitioner, Mr. Firaswa, is not well, Your Lordship, to argue the matter. That is why, Your Lordship, and it fixes short date, Your Lordship.
25 minutes this month, madam.
Huh?
25.
What is the matter?
Metal, madam, their promotion, madam.
Hmm.
They are working as a lecturer, madam. CIT, Central Institute in Kokrajhar, madam.
Hmm.
So, according to them, they are deprived, madam.
Hmm.
So, they filed this petition, madam. I am for a respondent, madam.
It's promotion matter.
Promotion, madam. Or lordship may after vacation.
Vacation?
Lordship, kindly fix on 25th or 27th, Your Lordship.
Oh, no, we have fixed open matters. Second week of December. Second week of December.
Hello.
It's a promotion matter.
Yes, Your Lordship.
All of you are working.
Yes, sir.
Yes, this is all. madam.
Then
On date may fix, madam.
otherwise, you could have taken up the matter on the ground of Mr.
Yes, yes, sir.
B. Rajkumar, London Council, appearing in this matter. Is indisposed, comma, Mr. So-and-so, London Council, for the petition, London Council appearing on his behalf and as consented by the,
I'm concerned, madam, because he's not, I'm not objected, madam.
as not, and prayer not being object, no, and the the phrase that matter will be adjourned to second week of December 2025. They are not being objected to by the London Council for the respondents. Same is allowed. List in the month of, in the second week of,
Madam,
December 20.
date may fix, madam, 8 December, madam.
there's no urgency. Second week.
Madam, I may not be there, madam, on the other days, madam, in second week, madam, from 9, 10, 11, 12, madam.
See.
Yes.
In that case, then first week,
First week.
of December, in place of second week. Yes.
Hello, that's.
Yes, please, Your Lordship. I beg to mention item number 12, Mallar. In this case, record was called for Mallar. So matter may be taken after, I did not collect the record, Mallar. So on 2 weeks may be given, Mallar. I have
Take-
taken the consent of that assignment.
MSA grant, Learner CGC. CGC submits them. The records which is supposed to be placed, is yet to be yet to be received. Therefore, press for listing of the matter after 2 weeks.
Yes, ma'am.
Prayer is allowed, it's after 2 weeks.
Master Black.
Yeah, please, Your Lordship.
Hmm.
Lordship, the concern of the others, I beg to mention item number 20 and 21, Your Lordship.
20 and 21.
20 and 21. Let the matter be taken up on the first week of December, Your Lordship.
Why?
So in this matter, Mr. D. Gogo is having a personal difficulty today, Your Lordship. First or any date before that, Your Lordship.
B. Gogoi,
D.
on the ground that Mr. B. Gogoi, learned Forest Department.
Forest Department. He's in.
Has some personal difficulty.
No,
Mr. Swain's learned council Appearing on behalf,
My lord, I am appearing a petition on my lord, a date may be fixed, my lord.
appearing on behalf of
Next week.
praise for listing of the matter
Monday
in the
or
second week of
Thursday?
December. Second week,
Second.
My lord, this is the pensionary matter, my lord, I am not
Yeah,
getting a
but-
date may be fixed, my lord.
prayer not being objected to by learned counsel, Mr. J. I. Burbuya, for the petitioner. Come on,
First week
Semis.
will be.
allowed, according to this, the second week of December,
My lord, instead of
2025.
second week, my lord, can it be first week, my lord?
second week.
My lord, this is the pensionary matter, my lord.
Yes, we'll take it up. Don't worry.
Obliged, Lordship.
The date may be fixed, my lord.
If that,
Obliged.
My lord, my senior is annual, my lord. He is unable to, I cannot
Ah.
vote today, my lord.
yes,
My lord, in this case, my lord, Mr. A.R. Talwindar is actually pursuing this matter, my lord. As per his, so, my lord, he'll be filing the affidavit, additional affidavit today, my lord. Uh, instruction received, so mindly, my lord, kindly let this matter be come up after any other date or, my lord, at two.
it too,
Any other date, my lord, it will be convenient.
on the, on the ground that Mr. H.R.A. Chaudhary,
My lord.
learned senior counsel is indisposed today, comma, Mr. So-and-so appearing on his behalf, submits that matter may be adjourned for 2 weeks. Mr. A. Fukan,
Yes, that's my lord.
Yes,
Higher
that's-
Education Department.
learned counsel,
Pending
submits-
counsel,
also submits that as per the order dated 12/11/2025. He would like to file an additional
Additional
affidavit
affidavit.
during the course of the day, which shall be filed during the course of the day. Consider the above. Let this matter be listed after 2 weeks.
A copy of affidavit of opposition, my lord, submitted by the two to respondent number 5, not supplied to me, my lord, a direction will be given though.
I'll give, my lord.
My lord,
Direction is
earlier,
not taken.
No direction is required.
Direction not taken, my lord, I'll give.
that is why I have,
You record your name, there so and so are also.
M.
present.
Hussain, respondent number 6.
Respondent 6. He is present. Your name, please?
M. Hussain, my lord.
And anybody else? Huh?
I have put respondent number 3, 4, and 5.
Hmm.
My lord, a date may be fixed, my lord, of course.
Hmm?
A date may be fixed, my lord.
He speaks today. You are seeking time. After 2 weeks.
Lordship, kindly pass over the matter for the time being.
Huh?
For time being, pass over the matter for the time being. My
Have you filed the affidavit? Last occasion, the final opportunity was granted for filing affidavit. You have not filed affidavit. Who is for the petitioner? C. Paul. K.P. Patel.
petition, I'm for the KPTC. So your lordship, we have filed our affidavit today.
Today?
Yes.
You are for?
I'm for APDCL.
Huh?
APDCL, respondent number
The
one.
main respondent,
Yes,
main respondent.
yes,
Okay, non appears for the petitioner on call. Mr.
C Paul.
Learned counsel for the petitioner. Learned counsel for the respondent. APDCL submits that he has filed the affidavit today. Mr. However, same is not take with the record. Next paragraph. Raised it to verify as to whether affidavit has been filed or not. Mr. If it is filed, to take the affidavit in opposition with the record, list after 2 weeks. And for example, 17. You have you filed? Limited, you're always limited. Okay. Hmm.
My lord, today speaks for instruction matter regarding my lord issuing NOC. I will sit in start from you. I do.
What is your instruction?
As per my instruction, your lordship kindly look at para 3 malad onwards malad.
Not onwards, you just tell us.
But he, prior to obtaining the NOC, he appeared in the examination on 27/6/2024 without obtaining the NOC or permission. And subsequently, while NOC was issued, malad, certain conditions are incorporated. In paragraph 4, the conditions are given, malad. If the recruitment process has already been completed prior to submission of this application, then the NOC shall be treated to be invalid. No department inquiry or vigilance inquiry is pending against the applicant. Well, here is the case, malad, admittedly, vigilance or the department inquiry was pending at the time of malad, he obtaining the NOC. So, malad, and he is finally dismissed from service, which was challenged the petition. And in fact, the will going to file the affidavit in opposition in the main writ petition during the course of the day, malad. Annexure C is the NOC malad order issued to so many incumbent, where the serial number at serial number 5, the name of Mr. The petitioner is there. The conditions are in the next page given, and that is why here is a case, malad. After dismissal, otherwise also is not.
Where is the condition?
Malad,
NOC was issued.
and NOC was issued annexure Z, malad, the flag mark malad portion, serial number 5. The petitioner's name is there.
Hmm.
And the next page, malad, to while giving the NOC, the conditions are incorporated.
Name of the petitioner is
At serial number 5, the name of the petitioner is there,
Amit Kumar.
malad.
Yes.
And the next page, to the conditions are incorporated. A, B, C, malad. Your lordship got it, malad.
Hmm.
So here is a case, he has not fulfilled this condition. The conditional NOC. Here is a case where the inquiry was pending at the time of giving the inquiry. That is why he is not eligible, malad.
It is hereby approved that no department inquiry or vigilance inquiry is pending against a council president.
And in fact, my lord, recently, after he succeed in the SSC examination, he approached the authority, my lord, for obtaining a NOC for appointment. Annexer H is the office memorandum to that effect.
So that time he was under inquiry, departmental inquiry.
My lord.
Then you have given the commission,
That
means
is,
NOC.
One of the conditions is that if there is no DPS pending, then only this is a conditional NOC.
You didn't know.
Admittedly, at the relevant point of time, there is a department proceeding pending.
Then why you have issued in this paper?
Malad, it is issued from the Malad, thorough scrutiny for this purpose. It is impossible. The incumbents, not only the petitioner, so many other incumbents of different Malad wings, Malad of the.
He was under suspension.
The
Departmental inquiry was there.
My lord, the conditional NOC is clearly states, if there is a department proceeding pending, this conditional NOC, my lord, cannot be applicable to petitioner. So,
Completion of the reports have been requested for appearing there for various higher posts.
interestingly, that is, I am pointed out that at paragraph 3 of the instruction, he had appeared to the examination paper 1 on 27/6/2024. That is prior to obtaining the NOC, madam. That is violative, madam. In other words, the conditional NOC is automatically invalid in view of the condition incorporated in the conditional NOC.
My lord,
Difficult.
my lord, my lord, the respondent authority, my lord, fully aware, my lord, about my application regarding my lord.
And then, no, that was there, but then you issued an NOC, conditional NOC.
But my lord, kindly see, my lord, the page 53, my lord, that is 1/8/2024, my lord. They forwarded, my lord, to the higher authority, my lord.
Not only forwarded. No, that has been decided now.
And my lord, the 13/2/2024, 25, my lord, they give my NOC, my lord, along with the other, my lord,
Yeah, that has been conditional.
Yes,
That's
my lord,
only-
condition-
That's which he has read out. Now 11/11, that has been rejected now.
yes.
It has been rejected now.
Rejected, my lord.
See, you were permitted conditionally.
Lord.
That NOC was issued subject to certain condition that no department proceedings or inquiries should be made. No, it should not be under suspension. All right. You should not be under penalty, something like that. So that's the
Well, Court of
admittedly, you accepted this order 3/2/2025.
Court of Inquiry, my lord, letter, my lord.
Huh?
Departmental proceeding, my lord, I have stated, my lord.
No, 13/02/2025.
That was my lord.
That time already you were there, you were under the department inquiry was there.
But court of inquiry, my lord, after my lord, permission, my lord.
No, the permanent
application.
inquiry is there, was there on 3/2/2025. It's very difficult.
My lord, 1/8/2024, my lord, kindly see, my lord, the court of inquiry was constituted.
No, when this NOC 13/2/25 was issued, right? What is your status?
My lord, that time,
What was the status?
offer of appointment was not issued, my lord.
No, it's not the question of offer of appointment. When you were allowed to participate, NOC by this office order 13/2/2025, it was a conditional. One is that no department inquiry or vigilance inquiry is pending. Other second is personnel is not serving any penalty period. That time you are not given a penalty.
My lord, court, my lord, kindly see,
And none of the above officials is under suspension.
that, my lord, on 13/2, my lord.
Huh.
13th February, my lord, but court of inquiry was held, my lord, on 5/11/2020.
No, it's not a court of inquiry. You just have you. Do
Well,
you have
Annex
this-
1 to the
do you have
document
the
clarify, my lord.
NOC?
Oh, yes, my lord, I got it.
Wait, you have annexed the NOC or
No,
not?
no, my lord, after, my lord, after, my lord, after 14/11, my lord, I have received, my lord, the proposal. 11/11. It was, my lord, 11/11, my lord.
Or no, 13/2
32, I have an X, my lord.
with the condition,
Yes,
where it is?
that is, my lord, 59 page, type copy, my lord. Page 57, my lord. Annex of 4, my lord. TL number 5. To
Page 58, it's clearly given.
Yes, my lord. My lord,
None of the above official is under suspension.
petitioner's number, my lord, serial number 5, my lord.
No, you were under suspension, page 58,
Yes, lord.
that time.
That time, yes, lord.
We feel for you, but law doesn't permit.
But my lord,
What can we do?
petitioner lost his, my lord, opportunity, my
What
lord.
to do?
Now, my
What
lord,
to
he is the unreserved category, my lord. Even, my lord, that his honorable court, my lord, regarding, my lord, dismissal of service, my lord. his
No,
honorable-
we're not going through that. Dismissal service one.
My lord, even then, my lord, they have not, my lord, filed any affidavit, my lord, till
My lord,
today, my lord.
Or it's
My lord,
filing
is
it.
going to file during the course of the
Madam,
day, my lord,
11/6/2020.
in petition.
No, that is not the issue here.
If my
Today,
lord-
today we're considering whether you should be allowed to, NOC should be issued in the meantime so as to enable you to join. That's the issue today. We're not on the merit of the writ petition now.
At least, my lord, otherwise, my lord, I have lost, my lord, opportunity, my
Can't
lord.
help it. Law doesn't permit you, because I thought that you were already permitted without any, unconditionally, without any conditions. The condition clearly says so,
But
that
that-
you knew that.
But already, my lord, that part of his letter, my lord, already I have, my lord, qualified, my lord, in medical test also, my lord.
No, it doesn't matter.
Well, court of inquiry was held, my lord, 8 on August 2020.
No, it's not a question of court of, we said that
before
you
that,
are, no, you are not serving as, serving the penalty that time. But then you are under suspension. Then, that's one of the three
But
conditions.
They were responded fully aware, my lord, my application for
It's not a
regarding my.
question of
permission.
error. That's why they have issued an NOC conditionally, with conditions, not unconditionally.
But for a moment, my lord, page 54, my lord, kindly see, my lord. Page 53 and 54, my lord. My application was page 51, my lord. My application was for permission, my lord, for appearing, my lord. That is 51. Then, my lord, they have communicated, my lord, page 53, my lord.
3/2,
The
3rd February.
13 to his letter part, my lord. Already I have completed entire process, my lord.
It's okay. But then you have accepted that only.
This, my lord, on my humanitarian ground, my lord, they may consider, my lord, to allow me, my lord. Otherwise, my lord, my unreserved category, my lord, I have lost, my lord, opportunity, my lord. Subject to the outcome of the my lord
Yes.
connected writ petition, my
No,
lord.
no, this is something dismissal from service.
My lord, if lordship allow me, my lord, I have one judgment, my lord,
For what?
for my lord, similar circumstances, my lord.
Saying what?
My lord, to join, my lord, this, my lord, to join the new post, my lord.
Huh?
Yes, my lord. My lord, paragraph 3, my lord, kindly see, my lord.
This was due to pendency of the criminal case and the issue out of matrimonial dispute,
Lordship.
and that proceedings was stayed by the High Court.
Yes, lordship.
Is there any stay in your
My lord, even my lord, dismissal regarding our high court, my lord, if lordship allow me, my lord, to allow the repetition, my lord.
huh?
Allow the repetition finally, my lord.
No, no. That's
Similar
very-
circumstances, my lord. Unauthorized absent, my lord.
Huh?
Unauthorized absent also, my lord.
No, no, unauthorized absent, that may be allowed, but then that is the penalty only. Today, why not on the merit?
Lordship, lordship.
Not necessary.
Otherwise also, my lord, that's CCS rule, rule 11.
Why,
In my lord.
be little considerate.
Well,
Can you allow him to join, subject to outcome of the,
my lord, I just pointing out
with a condition?
your lordship regarding the CCS rule 11, my lord, 10.
No, no, it's a, we are only on a temporary arrangement, we are not finally settling the issue.
My lord,
Since
which indicates that
the.
if a person is
writ
dismissed
petition-
from service,
That I understand. That's why I'm asking.
he is
Can you be
ordinarily
little,
disqualified.
can you
for-
be, sir, little considerate? That is why I'm asking.
My lord, I don't have any, my lord, rule,
See,
violating the rule, my lord.
you may issue again conditional NOC.
My lord, violating the rule. A person who was dismissed from service, rule says that he is, my lord, no longer eligible for any government appointment, my lord. And that issue is pending before this honorable
Who
court.
is
Writ petition,
disputing
my lord.
that, sir? Nobody is disputing that.
My lord. So,
Nobody is
at
disputing
this
that.
says definitely, my lord,
Suppose tomorrow if the writ petition is allowed,
my lord.
because everything.
That is there.
Huh?
But since by 22nd, he is required to be joined.
Ah,
We are on 18.
hmm.
I am going to file the affidavit in opposition during the course of the day. Your lordship fix the day, my lord, within this course so that the writ petition will finally considered for final disposal, my lord.
Where on IA today?
My lord.
Where on IA?
I am, my lord.
22nd is the last date, my lord, to join.
In main repetition, I am going to file during the course of the day, affidavit will be filed, madam. He may, my lord,
No, when main affidavit will be in CD. I'll consider and pass order.
highly obliged.
But Mr.
Alan Ding, my lord.
Ellen Ding, learned counsel for the petitioner. Applicant petitioner. Also
UK Goswami,
UK Goswami, learned
Central Government Council.
PGC, correspondence. By filing this interlocutory application, the petitioner and the applicant desperate for a direction to issue required NOC of the discharge certificate in favor, certificate in favor of the applicant. So as to enable him to join his new appointment as sub-inspector within bracket general duty in CRPF on or before 22/011, 11/2025. Subject to the outcome of the connected expedition. Being WPC 3223 of 2025. I'll pass the order. I'll think about it. I think we'll see.
Well,
I'll record your instruction. And then let us see if there's a way out
Mal.
that
Mal.
he can be allowed conditionally. I mean, it can be directed you to issue NOC. Again, conditional NOC. Right. After all, job. We'll see, huh?
well,
Obliged.
I see. This is the last, you are supposed to join on 22nd.
Lordship, on or before 22nd.
and I am going to file the application during the course of the day, my
No,
lord.
you file it.
Mal.
That is in the main writ.
My lord, my lord.
Main writ.
Main repetition, my lord.
We'll consider that also. You file.
Here, your lordship, Mr. D. Nath, he was actually handling this brief. He is on legs in port number 18.
And Mr. Mia also in leg, my lord, after some time, my lord.
After some time. Here also Miss M. Bhattacharya, additional senior government advocate, she is on legs. Your lordship may take it after some time, I'll just call her.
You start?
Lodge. After some time, Lodge.
You start?
Yes, Lodge.
All the case cannot be after.
Yes, sir.
Basically, this case is this petitioner was terminated from service on account of because of his misconduct. And thus you will find the impugned order at page 42.
40?
42.
Forty?
42, Annex F.
Yes.
Yes, Lordship. Yes, I'm reading the probationary constable of police number so Manas Pratim Hazarika, son of late Rajat Hazarika, was appointed on 1/6/23 in FVRO file number so. During appointment process as constable of police in APRO so Manas Pratim Hazarika submitted notarized affidavit swearing that he has not been convicted of any offense involving moral turpitude, and there is nothing in his character and antecedents which renders him unsuitable for appointment to the above mentioned post. Whereas file memo number so dated 8/1/24 of the Superintendent of Police DSB Nagaon, it is intimated that he was an accused in Jajori PS case number so under section 427, 4294, 325, 34 IPC, and the case has been submitted in charge sheet by Jajori PS case number so dated 35/80. Thus, he exhibited gross unbecoming conduct, concealing the fact of his involvement in the aforesaid case number of Jajari case while getting appointment in a PRO. In this regard, he has asked to submit a written explanation as to why he concealed the fact of his involvement in unlawful activities for which the police case registers prior to joining a government service, and why he should not be discharged from service for violating clause 5 of the appointment letter dated 29/5/23. In reply submitted by CM Manas Pratim Hazarika by his letter dated 3/2/24, reveals that he concealed the fact that he was accused in Jajori case number 7. So he submitted false affidavit while he was appointed as constable. In his statement, he stated that he was exonerated, which is wrong, and tried to mislead the organization. He was appointed in the post of constable on 1/6/23, and during probation period, his involvement in this case has come to the notice of this authority. It is also mentioned that as per appointment DDO number 160 dated 19/7/23, wherein it is clearly stated that the appointment of a recruitment constable on probation is purely provisional and may be terminated by APR authority at any time without assigning a reason whenever considered necessary. In view of the above, rule number 357 of the CMSO, Manas Pratim Hazarika presently posted.
Yes.
Yes. Thereafter, also we have filed a reply to their and a prior petition was submitted also after passing the Simpin order. That was also rejected also.
Obviously, after termination.
Yes, after termination, it was also rejected. Now the only question is, that I'm submitting is before passing this termination order, no proceeding was initiated against the petitioner.
Not resident.
It is I'm coming
You are probationer.
Yes, even it is probational, even if person is probationer, I'll come to that point. Even a person is on probation, he can be terminated only on the ground that if the authority is not satisfied in his efficiency during probation period, but the person cannot be terminated as a punitive measure. That is settled law. I'll come to that. If the order is on punitive, then departmental proceeding has to follow must have to follow. That cannot be dispensed.
You have not been dismissed, you have been terminated.
No, I have been terminated only because because of my misconduct. If order of if the basic grounds of termination of this order is
What is the requirement of advertisement of filing that antecedents?
Sorry,
Where is the requirement of filing your antecedents
in the in
advertisement?
yes. At page 28, Lordship.
Page 20?
Page 28, Lordship.
Yes.
6 number. Further, the appointees shall have to submit an
Submit a
update.
notarized affidavit as per
Yes.
provision the personal be department so in format of the. Where it is?
In cell number 6, Lordship.
Hmm.
Further, the appointee shall also have to submit a notarized affidavit as per provision of the personnel department number so and so, that 18/11/21. Format of the affidavit is enclosed at Annex 1. So here submitted Lordship the affidavit. Affidavit probably is not in the record also. So after submitting this Lordship, he has completed all this training period also, and during his service Lordship, after completion of his training period, while he was in duty Lordship, this first notice was issued to him, asking him to why he should not be terminated. Then Lordship, we have filed a reply Basically, issue,
I'm asking, what is the requirement of filing antecedents?
that is I'm saying, Lordship, page 28,
28, where does it say?
serial number 6.
Till number 6 says what?
Further, appointees shall also have to submit a notarized affidavit
Huh?
as per provision of the personal.
Where is this
Format,
provision?
yes, format, Lordship, is not here.
Huh?
Notarized format is not here.
Where it is?
It is not annexed, Lordship.
How do we know that this is the requirement? Page 30.
No, page 30, Lordship. E. Appointee shall submit notarized affidavit swearing that he is not involved in any criminal or unlawful activity in the eye of law. Appropriate steps will be taken in case of
Recruit constable.
misrepresentation of the fact found in the record.
Recruit constable will be on probation for a period. Shall be levied. Page 30.
Lordship.
Appointee who submitted notarized affidavit swearing that he or she is not involved in any criminal or unlawful activities in the eye of law, appropriate steps will be taken in case of misrepresentation of facts found by the authorities.
Yes. So Lordship, this,
This is the requirement. Why you are referring
no,
to?
I am saying,
clause six?
Lordship, there are format I'm saying.
Hmm?
Format of affidavit. Lordship.
Where is the format?
That is what I'm saying, it's not annexed, Lordship.
So where is the requirement of having that antecedents?
This, page 30, Lordship.
Then
Yes. I thought Lordship was asking for the format. I'm sorry. So Lordship, this is the main case is that he filed an affidavit, Lordship, at the time of his appointment. He was not involved in any case of moral turpitude, Lordship. The only issue is that there was some dispute regarding his ancestral property with his elder
that
mother.
I have
Yes.
understood, but the
That-
criminal case was there.
Criminal case was there.
Huh?
Now the only issue is, Lordship, whether the full-fledged Lordship inquiry proceeding was required to terminate before his termination or not. That
No,
is-
no, it's not this.
that-
Issue is whether you have concealed it or not, whether you have filed a notarized affidavit
Yeah.
swearing that you are not involved in any criminal.
Yes, Lordship.
Where is that notarized affidavit?
Notarized affidavit not with us, Lordship.
Huh?
It is not in the
So
record.
how do we know?
Notarized
This is
affidavit,
the
it
main
is admit-
issue.
It is admitted fact that you have submitted the affidavit that there is no
Saying that
criminal
you are
case.
not involved in any criminal case. Huh?
So,
Lordship, then we have to check if, I think this will be available in the record, Lordship, we can produce it.
also, we can also file additional affidavit, no issue also.
Huh?
We can file additional affidavit regard to bring on record the affidavit also. Notarized affidavit. But we are admitting that we have submitted an notarized affidavit.
If you are admitting matter, it's there.
Yes. So now the only, my only submission is that Lordship. I have also annexed the, quoted the observation made by the Honorable Apex Court and also some judgment that whether Lordship, if person is to be terminated on a ground of misconduct, whether Lordship proceeding is necessary, even if in probation period. Now law is settled that if, even if he is in probation, if the termination is for misconduct or is punitive, then Lordship proceeding has to be
Yeah.
initiated.
If you are admitted, what's the question of, it's a mere formalities or empty formalities?
Because the only ground is that although we have submitted affidavit, the case which is
You are admitting that you have.
admitting us, but the case is of civilness as per the
Why
petitioner
I'm
was
not
under,
concerned?
no Lordship, this petitioner was under bona fide presumption that the case is of civilness, so it is not necessary to disclose at the time of appointment because this case is regarding Lordship on ancestral property. So he was under bona fide presumption that is the civilness, sir, not a criminal, sir. Yes, that is his only his Lordship
That
mistake
is
is
the
that,
only excuse you are trying to make now.
and yes,
That is the only excuse you are trying to make now.
yes, because we have also replied in Lordship. After getting the so-called notice, we have replied that yes, we are under bona fide presumption that this case is of civil nature, so we didn't.
Where is the so-called notice?
So called reply, Lordship. We have-
So-called notice,
Notice is also there, Lordship.
where it is.
Lordship will find to page 36.
Yes,
Page 30, explanation, Lordship. During your appointment as constable,
you submitted notarized evidence swearing that you are not involved in any criminal unlawful activities in the employ. You have not been convicted of any offense. There is nothing in your character like that. By so and so, it is intimate this case has been registered against you. Eh?
then Lordship, we have replied in page 37.
It is indeed a fact that I swear an affidavit, notarized affidavit before my joining as per the order dated, where I mentioned that I am not involved in criminal. In reality, not involved in criminal. That the case will the outcome. When you filed that affidavit, it has been whatever the criminal case. The case is at the verge of completion wherein I will be acquitted by the honorable court. Huh? Where is the order acquitting you?
Lordship. At page, Lordship, 46.
Huh?
Page 46. Just I need the order. Page 46.
46. Case record put up accused person, namely Manas Pratima, due to a change in circumstances. Due to lack of incriminating measure. Yes, madam.
Lordship, the main cause of these things that we have stated in our affidavit, Lordship, page 52, paragraph 4, Lordship.
Yes.
That after being selected and recommended for appointment by the state level police recruitment board Assam, the petitioner was appointed in this organization as constable subject to fulfillment of the criteria laid down, terms and conditions of appointment. As per conditions, the petitioner at the time of his joining in service on 1/6/2023 submitted a notarized affidavit dated 29/5/2023 in the prescribed format, swearing inter alia that there was no pending criminal case against him and nothing in his character and antecedents which rendered him unsuitable to retain in the post he joined. But in the report of verification of CA received by
What is CA?
Lordship.
Character and
Character and
antecedents.
And
Huh?
received by
Perhaps it's a correct
Character
character and
antecedents.
antecedents.
By the Superintendent of Police, Nagaon, Assam, it revealed that a case had been registered against him at Jajori PS, Nagaon by so and so, dated 24/4/2018 under section so and so, which was charge sheeted on 31/5/2018 and then was under trial. The reporter Superintendent of Police, Nagaon, exposed that there was a criminal case pending against the petitioner at the time of his joining in service. But he submitted affidavit to the effect that there was no criminal case pending against him. He concealed an established fact, and thus he not only violated the terms and conditions of his appointment, but also exhibited indiscipline, unbecoming conduct, and doubtful integrity, which rendered him unfit for retention in the police force. The petitioner was therefore asked to submit his written explanation as to why he concealed the fact of his involvement with the above-mentioned case and why he would not be terminated from his service for violating the terms and conditions of his appointment by this office memo number so and so. The petitioner submitted his reply to the explanation, wherein he stated that he paid less attention towards the case and was in general presumption that it will not affect his service, which indicate that he had submitted affidavit of false declaration, thereby misled the appointing authority and thus found not satisfactory. The petitioner was in probation period and therefore terminated from the post he joined, that is constable of APRO with immediate effect by DO letter number so and so on the basis of terms and conditions laid down in the appointment in DO, Lordship. Lordship, then the service of the petitioner, he again addressed to the Inspector General of Police Communication, Assam Guwahati as appellate authority, requesting to allow him to continue in service, considering his guilty and unintentional mistake and misrepresentation of the fact. In order to consider his fair, he enclosed a copy of the order dated 16/2/2024 passed by the Judicial Magistrate First Class Nagaon, whereby he has been acquitted from the said case of Jajori PS mentioned above.
Okay. I've
Lordship,
read it.
yes, the authority.
So he admittedly, he submitted the.
Yes, false,
false
yes, Lordship.
affidavit,
Yes, Lordship.
thinking that he was not involved in any criminal case,
Yes,
whereas fact remains that there was a case pending against him.
Lordship.
Well, a criminal case pending against. So
Yes,
as per the terms of the appointment, you have terminated him.
Yes,
Yes. Now, he has been acquitted
Lordship.
and the case arises out of family disputes, maybe a criminal case. Why don't you reconsider?
Lordship, because the conditions, even the appointment letter, it contains these things, Lordship. If your Lordship may kindly peruse Annexure A of the writ petition, page 25, which is the order of appointment, Lordship. Kindly peruse the terms and conditions from page 27 onwards.
Yes, I've seen it.
Yes, Lordship. So, the number one is his, during his or service period, she may be deputed to his or service may be placed on attachment or on secondment basis within the Assam Police Organization, so and so. Second, Lordship, while on such deputation or on attachment or placed on second basis, he shall continue to be guided by the Assam Civil Services Conduct Rules 1965 and Assam Police Manual and rules related to both the Act and Manual. So once he accepted the appointment, Lordship, he comes under the purview of this Lordship. So as per, because everything has been done as per the Assam Civil Service Conduct
But
Rules.
there are no proceedings.
He admitted, Lordship, how can there be proceedings? When the guilt is admitted, where there is any requirement of going through all this, Lordship. He has admitted his guilt, Lordship.
No, what does it say? Page 13. The boy appointees who submitted notarized affidavit swearing that he or she is not involved in any criminal or unlawful activity in the eye of law.
Yes,
Appropriate steps will be taken in
taken in misrepresentation found by the authority.
authority.
Yes, so these things are there, Lordship.
What is the appropriate steps you have taken?
These steps is as per he has been,
given.
explanation has been called for, Lordship. And he admitted, it's on record, Lordship, he admitted his guilt. So
Not-
when there is admission of guilt, Lordship, does it warrant any further, these things, Lordship? enquiry proceedings and all this procedure has to be followed. There is no such lordship.
But there's an explanation to that.
Lordship.
He presumed that it is not,
There is
no
nothing
bearing.
presumption lordship. And this is also a discipline force lordship.
Huh?
Very, they are involved in the security, safety and security of the public
The
lordship.
criminal case was what, of what?
No, criminal also lordship, there is want of these things. There is not that he has been honorably acquittal. This is also one point to be noted, lordship.
No, no, if it's.
Yes, lordship, only mere acquittal does not signify his,
No,
this
no,
things,
it's not
lordship.
a discharge, madam, it's a acquittal. There's no evidence. The case could not be proved by the prosecution.
Lordship,
Therefore, he has been acquitted.
acquitted because,
Not a
this could not-
benefit of doubt also.
benefit of doubt, so benefit of doubt and honorable acquittal, these two are different things, lordship. And there are many judgments on that effect.
This
Yes,
is not
lordship.
the benefit of doubt. He has not
There
been
are-
acquitted on benefit
There are
of doubt.
number of judgments, not only of this High Court, the Honorable Supreme Court also on this count, lordship.
I know that. There's a difference. What do you mean by honorable acquittal? What I'm saying is, he has not been acquitted on the ground of benefit of doubt, right? He has been acquitted because no case has been proved against him. That means what?
But lordship, these two are two separate things, lordship. Criminal, the parameters on which the criminal cases are, that means conducted,
No,
lordship,
before that,
this
when
is
you are-
a different thing,
When
lordship.
you trying to schooling me that there's a difference of honorable acquittal and the benefit of acquittal or benefit of doubt.
Benefit of doubt.
I'm on that right now. I'm not on
Lordship, there
on
are-
the case. You tell us what do you mean by honorable acquittal?
Lordship, these are.
Acquittal honorably.
Yes,
Number
lordship.
one, you tell us what is the benefit of doubt when it accused is, convict or what is acquitted. Accused is
Okay, lordship,
acquitted.
kindly take it after some time, lordship. I shall just go through and I shall appraise your lordship.
No, when you say that, tell us.
Lordship,
bearing.
on the basis of some judgments,
When you
lordship.
say that when he has not been acquitted honorably,
Lordship,
you read the order. Where is that order?
Page 46.
Ah,
The result considering the facts and circumstances.
I found that the prosecution has miserably
Judge-
failed to prove the accused person is guilty of committing offense. I acquit the accused person and set him at liberty. What does it mean? When the case, when no case is proved against the petitioner, and the prosecution failed to prove the case, is it not an honorable acquittal?
lordship, these parameters on which the criminal case is of separate footing and this is of his discipline and conduct rules, lordship. Is
Madam,
unbecoming of a,
Madam, the point I'm trying to interact with you on the point which you have raised unnecessary, which is not connected with this present matter. I'm also conscious in the criminal proceedings,
lordship.
it's a proof beyond reasonable doubt. But in a deeper, it's like civil proceeding. Preponderance of probabilities. That is law is well settled.
Lordship, I shall see on the judgment, lordship, the departmental proceedings and acquittal in the criminal proceedings, lordship. The nature,
Madam, I have told you, in criminal proceeding, it's a proof beyond reasonable doubt. In a departmental proceeding, preponderance of probabilities.
yes, lordship.
That's all.
Yes, lordship. So this judgment, this is of the natural proceeding, nature of proceedings being wholly separate and distinct. Acquittal in criminal proceeding does not entitle the delinquent employee for any benefit in the matter or automatic discharge in departmental
I'm
proceedings.
conscious of this, madam. I'm conscious.
So
I'm conscious of that.
Yes,
What I have
Lordship.
just said, they ask you is, by now, he has been acquitted. That is what I just mentioned. I am not, for a moment or a second, I am saying that since he has been acquitted, he cannot be terminated. I'm not saying so. What I am saying, subsequently, he has been acquitted, and the nature of the offense against was also not that it's a out of the family disputes.
But here in the judgment, nothing is reflected. This is family dispute or anything. There is nothing, no, even these things are their lordship. That this, we can believe that this is of family dispute. There is nothing on record such like this lordship. There is not a single whisper in the order passed by the lower court lordship, acquitting the petitioner.
Yes.
Lordship. Lordship, I have given some judgment, Lordship.
What sub-judgment, which is relevant?
Relevant, Lordship, I am giving Lordship.
How many judgment?
Around 7 judgment I have given.
Why 7-8 judgment? Where
Yes, I am
7-8
reading one,
judgment
Lordship.
is
Yes, I am
required?
reading one, Lordship.
Just give the most relevant.
Yes.
Unnecessary.
The first one, Lordship, may I have it? First one, 1992 to GLC. This was the division bench judgment of this honorable court. Lordship will find paragraph number 11. This is Tabang Pasar versus State of Arunachal Pradesh. The first one, Lordship. Paragraph number 11, Lordship. Paragraph number 11 of this Tabang Pasar versus State of Arunachal Pradesh. Regarding the necessity of holding a full-fledged disciplinary proceeding, Lordship. Lordship, got it, paragraph number 11.
In this case, any show cause notice was given? There was no show cause notice.
Same
In this
for-
case,
Same putting, Lordship, this judgment also.
where?
This judgment, Lordship, of paragraph number 11 and 12. Only because only so-called notice was given, Lordship, no proceeding was initiated. So,
From the parent decision about this clear that in case where the proposal is found to be that during the process of liable to be displayed without any legal abuse to provide him any opportunity. But in case the order term is not based on this. There is a act of misconduct. This is whether in this case,
Yeah.
any so-called notice was issued.
In our case, Lordship,
Here,
the explanation was short for Lordship.
huh?
Only explanation was short for Lordship. No, that is-
Where do you get it?
explanation
Not
was-
in our case, here,
Here.
the case which you are relying.
In this case, also only the stand of the department was that since he was on probation, it is not necessary to give any notice. So he was immediately terminated. And the
In
other,
your case, the notice was given to you.
no, only
Opportunity
court
was
has said,
given.
court has said not only the notice, the other judgment Lordship may kindly have other judgments of Supreme Court also.
One by one, sir,
Lordship,
please.
only
You are
explanation
jumping
was
from
called,
one to one.
only explanation was called for Lordship.
Huh?
Only explanation was called for from this petitioner and he has replied to the explanation Lordship, nothing more Lordship,
Where?
in our case.
I'm not asking in this case,
In
which
this
the
case,
case which you are relying on.
Yes, in this case, no notice Lordship,
Then
immediately he was
there
terminated.
is a difference. That's why no opportunity was provided.
No,
Your case,
Lordship,
there was
kindly-
the opportunity was given
no,
to
Lord-
explain.
Lordship, can you read the language of other judgment also, Lordship? Can you read the language of the judgment? We are giving in Lordship, so notice doesn't fulfill the criteria as stipulated in the service rule Lordship. They have to follow the service rules.
What is the service rule?
This some service, discipline and appeal rules.
What does it say?
He said Lordship, the procedure they have to control Lordship.
Which one?
They have to, when charges, the charge has been heard by this delinquent Lordship and accordingly he was given.
Even for probationer.
Yes, that is why I'm saying Lordship, the other judgment.
Which is the other judgment?
Lordship may have the State Bank of India and others versus Pollock Medi.
This 20.
Paragraph number 26 and 27. Just I believe paragraph number 26. Lordship will find internal page 20 correlated.
Let us see Assam rules. This rules, huh? Where is for the probationer? Hmm?
Professional rules is not, I'm saying Lordship, regarding the procedure to be followed. Lordship. Disciplinary proceeding.
For a probationer,
For a professional, there is no such Lordship.
then why you are relying on this?
I'm only saying that Lordship, they have to follow the disciplinary proceeding rules,
Huh? Even if for probation,
even if in non-probation.
why? How you, this will
Because
be
he has been terminated not because of his inefficiency in service, but because of his misconduct. So if it is a misconduct Lordship, then the proceeding has, he has to be given reasonable opportunity and otherwise it will violate Lordship Article 311. The rule nine of the state rules will provide the procedure for imposing penalties. Rule 9 of this Assam Service Discipline Appeal Rules 64 provides regarding procedure for imposing penalties. So they have to follow this procedure Lordship. Since
This is for permanent employees.
no Lordship, even in probation also, that is why I'm saying Lordship.
No, us.
That is a
From the
judgment.
rule. Judgment will come, go later.
Rule Lordship, rule is not specific regarding the probation.
Huh?
Only in the time, in the, their.
Then why you are relying on that?
I'm not telling, I'm just saying that Lordship, since even if he is on probation, since his termination is for misconduct, the department must have to follow the disciplinary proceedings. That is what I'm saying. And the other judgment, Lordship, the law is very much clear, the apex court also. This 2013 3 SCC Lordship 607, that's a notice, paragraph 2627. Subsequent to that, Lordship, another judgment is passed by the Honorable Apex Court Lordship. It is on 2015 15 SCC. Same law point is taken. Even if in probation, if the termination, the grounds of termination is misconduct, then Lordship complete proceeding has to be followed.
Where it is?
Yes. Lordship, taking up the Pollock Modi case. Paragraph number 26 and 27.
Hmm?
26 and 27 in 2013 CSCC situation. And next is also and in one judgment lawsuit, the language is very much clear that I have mentioned lawsuit 2008 to SCC.
I'm not getting the page. Please mark the page.
Lawsuit.
Ah, Boro. What is this? Palak Mode,
Palak Mai.
para 26.
26 and 27 laws.
You read it first. There was a rule for recruitment of the rules which regulate the probation and confirmation of officers of the bank.
Yes.
Here, where is the rule in your case?
Lawsuit, what I am trying to submit lawsuit is that in both the cases also lawsuit, they were on probation and they were found some misconduct and immediately they were terminated.
When you are relying on this Assam Service Rules, 1964,
I'm not really, I'm just saying lawsuit that if,
and there was a particular rule in this matter,
The-
Palak Madi's case.
but court has said,
So Rule 15 and 16,
yes,
which regulates the provision and confirmation of the probationary
yes.
employee.
But why I'm relying also this judgment is that only the language used by the Honorable Apex Court that even if on probation, the department must have to follow the procedure. That's it. That's
Lordship, this is not his pleaded case. Let him show any paragraph on this particular.
Judgment is bad in
No,
law.
no, we are not on judgment. In his pleading, Lordship.
Pleading
He
is
cannot
not-
take it after thereafter,
That-
Lordship.
That is in my.
Let him
grounds. judgment-
consent to his restrict to his pleadings only.
He's trying.
There is
he's
not a
just
single
trying to
whisper
divert
on
the
these
mind of
things,
the
Lordship.
lordship, nothing more. He's just trying to divert the mood. In my grounds, I specifically mentioned that impunity is bad in law.
The
I
bad,
think-
what
yes,
bad, Lordship?
what bad?
Nothing is
Now-
explained
now I-
nowhere, Lordship.
What that now? I
No,
will-
no explanation, no infirmity
not
has been
necessarily-
pleaded in this
not
petition, Lordship.
necessarily on grounds. Now I will interpret what is bad in law.
You read para 26.
Yes, lordship, I had the only one copy. I have given a list of books, lordship, that's judgment I have given this. A list of book I have given lordship. But 2010, 8 copies I have, lordship. 2008, one SS.
You just decide which judgment you are
All
relying.
judgments
Don't
saying same thing.
whatever is huh?
All three judges are saying the same putting lordship.
If this is same putting, give
Yes,
the
that is-
latest.
Latest I am giving lordship. Latest is the Ratnesh Kumar Sodri versus Indira Gandhi Institute of Medical Science.
There must be some the particular rules regulating
rules
the
is there.
profession.
Here also, there will be rules to confirm a service of the probationer.
Where?
The
Under
rules-
which rule?
The rules lordship that it mirrors. Ratnesh Kumar. Ratnesh Kumar. Ratnesh Kumar Soto. Para 26 and
Where on Palak Madi?
the same lordship. Polak Modi has been referred in Ratnesh Kumar. Subsequently,
Palak Madi to it's very clear.
Clear.
Para 26 says that there were the rules for the bank.
27 lordship language.
Rule 15 and 16, which regulates the provision
Yes.
and the confirmation. In that context, only Supreme Court said so.
26 and
Then,
27.
then
The
this
Ratnesh-
is,
Polak Kumar is relied upon in Ratnesh Kumar case lordship.
Yes.
And next lordship will file.
In Palak Kumar, the ratio of appointment judgment is that
Yes.
the probationer has no right to hold the post and his service can be terminated anytime during or at the time so.
And
In the facts of the case, the court proceeded to state that there is a marked distinction between the concept of satisfactory completion, so and so. They held that at the end of the period which is referred on for confirmation, probation and bank, probationer and the bank's right to punish a probation for any defined misconduct. Misbehavior means in a given case, the complaint authority may deciding the issue of suitability probation to be confirmed, ignore the acts of misconduct, terminate his without casting any aspersion on his thing which may adversely affect his future welfare. But if the misconduct is the constitute the basis of the final decision taken by the complaint authority, dispense with the service of the probation albeit by non-stigmatic order, the court can leave tribunal and declare that in the guard with permission the employer has punished them for an act of misconduct. So it was not a case of misconduct.
misconduct laws.
It was a case of misconduct in your case.
It's amount to misconduct.
Why?
Lordship will see the impugn order they have mentioned.
No, it's simply
No,
the
Can see the impugn order. Can see the impugn order. Lordship.
it's simply on the basis,
Lordship kindly see the impugn order.
on the basis of your concealment of the information.
Exactly. Lordship
And
kindly
the
see the
false
first
affidavit.
impugn order. Lordship kindly see. Kindly see the impugn order. Lordship.
Read it.
Yes,
Actually.
I am reading Lordship. Just relevant person I am reading. Whereas filed memo number so and so of the Superintendent of Police, Nagaon, Assam, it's intimated that he was an accused of Jajuri PS case number so and case has been submitted in charge sheet by Jajuri PS case number so and thus he exhibited gross unbecoming conduct, which what I could understand Lordship is misconduct. Exhibited gross unbecoming conduct concealing the fact of his involvement in the aforesaid PS number so. Now, the another judgment, if the copy Lordship there in my 2008 one STC Lordship. Four to three. Paragraph number 6 in this case also, 2008 1S.
Undisputedly based on the findings that the inquiry had been made behind the back of the respondent.
Not just complete.
Had the result of the preliminary inquiry been taken into consideration only for the purpose of judging the suitability of the continuing service, same could not have been said to be foundation for terminating it.
The next
Here
step-
exists a distinction between the motive and the foundation. If the misconduct is foundation of such an act, the same will be bad in law if it appears to be innocuous one.
Even it is unquoted Lordship, it's bad in law.
Huh?
Lordship, the last line. If misconduct is the foundation of such an order, the same would be bad in law, even if it appears to be an innocuous one. Even if it is innocuous Lordship proper, then also it is bad in law Lordship. In our case also Lordship, because of our misconduct, we have been terminated. And the other judgment Lordship in my writ petition, I have quoted some judgment regarding filing a false
See,
affidavit.
misconduct during the probation is one thing, and your the action against you on the basis of false affidavit or
Also-
whatever is it's quite
No.
another thing.
Lordship, misconduct, that is why I am saying that all this judgment has been Honorable Apex Court has cleared the Lordship.
Not
concept
all
of
the judges. How
misconduct.
many judgments you are relying? Tell us.
Yes, and in my writ petition Lordship, kindly see.
Yes. Sir, give me judgment which you are relying.
Lordship, since Lordship one by one word is coming, that is why I am relying upon all these judgments, like this Ratnesh Kumar, this Palak Modi, and this Nehru Yuva Kendra Sangathan and Tabang Parsa. All these judgments are giving one by one Lordship concept of misconduct and the procedure they have to
So
follow.
you give the latest and most relevant,
Yes.
not all the judgment.
Lordship.
You
This
decide.
Ratnesh Kumar Lordship Chaudhary and Nehru Yuva Kendra Sangathan.
You decide. You decide. First
Yes.
you decide.
And
Please let us not
yeah.
burden ourselves with unnecessary citations. Give the most relevant and we'll consider.
yes.
This is what.
Number one, I am giving Lordship. The first one, Tabang Pasar. Tabang Pasar versus State of Arunachal Pradesh.
Tabang?
Pasar, P-A-S-A-R. Tabang Pasar versus State of Arunachal Pradesh. It was reported in 19
PA?
P-A-S-A-R.
Person.
Mm.
AP.
Then,
Reported in
Lordship Ratnesh Kumar Chaudhary,
RA.
R-A-T. R-A-T.
Is reported in this.
Reported
Tabang.
in 2015, 15 SSC.
Tabang Pasar.
No, Lordship. Tabang Pasar
Arey
reported.
yaar, why you are?
Tabang Pasar Lordship reported in 1999, 3 GLT, page 90.
1999?
3
GLT?
GLT, page 90.
Para?
Para 11 and 12.
Then
Lordship will have 2015, 15 SCC 151.
151.
Yes, Ratnesh Kumar Chaudhary.
Para?
Yes. Para 26, 27.
Then
Lordship will have 2008 2 SCC, page 479.
2008 2 SCC.
2 SCC 479.
479.
Nehru Yuva Kendra
Para?
Para 6.
Hmm.
Regarding Lordship requirement of disciplinary proceeding, the other is Lordship 2011 4 SSC.
Hmm.
644.
Para?
Para 8, 9, 10, 11 and 12.
Then
Lordship, yes, Lordship will have 2024 5 SCC.
hmm.
264.
Hmm.
Ravindra Kumar, para 20 and 24.
This is on what?
Regarding Lordship, if person file any false affidavit during his joining, what consequence or what order or what remedy is there or what the department should do? It has clearly explained us. Mere submitting a false affidavit. the police-
2024.
Yes, 2024.
That is the most relevant one. Rest
Yes.
are unnecessary.
Yes. And
Huh?
and 2014 judgment was related to 2016 also. Three judges judgment is there. 2016 8 SCC. This was passed by 3 judges bench in Supreme Court also.
Saying what?
Saying this same thing was of 2024 relied upon.
That has been relied in
Yes.
2024. See, this is very
No, Lordship.
difficult.
Yes.
You read the 2024 judgment,
Yes.
right? And then whatever is relied on, you place all those judgment relying on that. This cannot be. What? We don't have the time to go through all this thing.
Yes.
Unnecessary. You rely a judgment, place a judgment which is most relevant in the latest.
Because Lordship, what I understand.
All these judgments they have relied from 1950s. You starting placing all those judgments
Yes.
one after another. It will take months.
Sometimes also question of the facts and circumstances of cases comes. So that is why Lordship, I think Lordship,
See, what is relied on there, that will be relied on the facts and circumstances of the case only.
Lordship.
What is not connected, how they will rely.
This judgment is enough Lordship for considering my case.
So 2024 is modern enough.
Yes. 2024.
That was I was asking from the beginning. This is a wastage of time. Yes. That's all.
Lordship.
Ultimately, what is your submission?
My submission is that, Lordship, first submission is that even if he was on probation, there should have been a full-fledged disciplinary proceeding to terminate the person because of misconduct. And second thing is that the Supreme Court has said,
If it is misconduct,
EAB, if it is misconduct.
yes.
And the second is that, Lordship,
According to you, the termination is on the basis of the.
his misconduct.
For misconduct.
Yeah. And the second is, Lordship, the Supreme Court has said the mere submitting a false affidavit at the time of joining while he might be of 18 or 19 years old, there is indiscretion of the person to commit sometimes like some stifling, Lordship, like there might be some incident, Lordship, that should not be considered as the foundation to dismiss it from service, Lordship.
But when you have admitted already,
Admitted position is that because I was under bona fide presumption that this is of civil
your
nature.
notice were given.
Notice, yes. No explanation was called for, Lordship. This
Notice
is not a
was-
so-called
it's
notice.
So-called. Explanation is what?
Yes. So, Lordship, only the two grounds is there.
Opportunity was provided to you.
Of
Although
course,
there was there was no disciplinary proceedings
yes.
as such, but then opportunity was provided to you, where you have admitted and trying to make some excuses.
Yes.
That I believe, I presume that it's not bearing and all those, it was not a criminal,
Yes.
difficult
civil nature
criminal
of-
case, but it's out of a family dispute,
Family feud,
something
yes.
like that, which may be your excuses, right? But in fact, remain that the opportunity was provided to you. And
Uh,
at the same time, you have admitted
Opportunity of full-fledged
that you
opportunity.
have filed an affidavit
Yes.
concealing that there was a criminal case against you.
Lordship, the disciplinary proceeding, the procedure of initiating disciplinary proceeding is something
But
different,
then
like giving
the
explanation.
acquittal is after the termination.
Yes. Lordship, while explanation was called for, Lordship, we were asked to provide if we have been acquitted. So
If
before
madam-
getting the acquittal order, Lordship, we have been terminated.
if Madam can show her magnanimity, then
Yes.
only your case will be allowed.
There is nothing in the
If
order.
he
Lordship.
doesn't show any magnanimity,
Yes.
can't help it.
Lordship will consider, I believe Lordship will consider, because this is a good case, and otherwise, one more thing is that, Lordship, one time submitting, my client has informed me that he is so diligent to this service. Now, for subsequent, he again applied, again after termination. Now he has been again, Lordship, selected, verification is done, only this part is done. Appointment.
See, who in this world say that I'm not diligent
Lordship, regarding the
and
conduct,
I'm not innocent,
I'm saying regarding conduct of this.
I'm not
process.
dutiful,
Yes,
all right?
Lordship. Again,
Every accused says that I'm innocent. That's all.
so that must be sufficient, Lordship will consider my.
And he has
case.
also rightly pointed out the submission you have made
Yes.
out of the 100% you have submissions made, you have only pleaded not even 5% in your writ petition. You have filed a writ petition,
Yes.
all right? Then at the time of hearing, you had a research in placing all those cases.
Lordship, now we are in learning stage.
Which is not your pleaded case.
No, Lordship, pleaded in, while Lordship we file an appeal or writ petition, Lordship, we basically say that the impugn notice is
No,
valid.
that should not be practice. You
There is
being a-
actually- this is our very.
you being a busy lawyer, you may not have the time.
Lordship, I
The
also
way,
not
no,
busy-
way out is, I mean, the best, the course of practice
In course of
is,
practice, Lordship, we have been.
course of practice is, way we should practice is, first you research,
Yes.
that file the case.
That is, I have quoted all the judgment. The judgment that now I am.
I understand.
Yes, I have quoted in my
This
petition
court
also.
also had the same,
Yes.
same experience.
I have
First,
quoted,
we'll immediately file the case, then at the time of hearing, we charge research.
But
Then
that-
we come to know that nothing has been pleaded.
my practice is something different, Lordship. That is why I have quoted all the relevant paragraph in my petition.
Huh?
Relevant paragraph of the judgment I have quoted in my petition also.
Hmm.
So before filing, Lordship, I have searched it. How
Okay.
can I, Lordship, give relief to my client? I
Huh.
have quoted in my petition also regarding the relevant paragraph of the judgments.
Okay.
Starting from Lordship will file page 13.
And you don't have to quote. In
I
fact,
have quoted Lordship in my petition.
you don't have to quote.
But only to satisfy the court on the first day, Lordship.
What? You think courts are full?
No, I'm sorry, Lordship, I'm not saying. All judgment, Lordship, 2024 judgment also I have quoted, Lordship. In
Huh?
24 judgment also quoted in my petition at page,
24 judgment?
yes, at page 18. Before reporting the case, Lordship. This case was initially not reported, subsequently reported, Lordship.
You quoted how many judgment?
3 judgment, Lordship.
Then,
Other judgment are like, it was with me, Lordship, I have not quoted, but the oral relevant, Lordship.
yes. Yes, madam.
Lordship. Lordship,
That's
my-
all.
no, Lordship. Because whatever now has been submission forwarded by the council, Lordship, this is beyond pleading. So there only, his case is only based on the Lordship, the criminal case, then acquittal and non-consideration by the authorities, Lordship. And this is a admitted fact that the petitioner has admitted his guilt, Lordship, that he has suppressed. This is up to him, whatever he understood or not. This is not the purview of the authorities, Lordship. Lordship,
See, let us see, we'll go by the law. See, probationer can be terminated on the ground of suitability.
Yes.
yes,
There is no requirement, no,
yes, Lordship.
Yes.
no proceeding.
Yes, Lordship, Lordship.
But if the imputation is on misconduct, you have to follow certain, I mean, the basic principle, I mean, proceedings, which you have initiated initially. But in the midway, you have decided to terminate on the ground of misconduct, on the ground of violation of or filing of false affidavit, concealing the criminal case pending against him, which according to is a misconduct. If it is a misconduct, a minimum procedure has to be, I mean, the proceeding has to be followed. That is what the law says. If we go by the words and tenor of your, the order. Right.
Lordship, when there is a clear admission, so there are, I think, no provision even to conduct again, because he already has accepted. He has own admission. So
These are
to
also,
my humble submission, Lordship,
Yes.
admission does not call for any further inquiry, Lordship, because this has been properly admitted by the person concerned, Lordship. Where is the scope and why again the inquiry has to be conducted?
M. Bhattacharya.
And Lordship, regarding one thing, Lordship, I just want to place, I just don't know whether
Yes.
that yeah. Two judgments of the Honorable Supreme Court, Lordship. One is Commissioner of Police, New Delhi versus Meher Singh.
If admitted, no further proceedings. Yes. Judgment,
Yes, Lordship.
just give the citation.
Yes, Lordship, I am giving.
Just tell us the citation.
Lordship, one is of 2013, 7 SCC Lordship,
2013,
7
7
SCC,
SCC.
685 Lordship, I have the copy.
Yes, 685 para.
For the Lordship. Lordship, Paras Lordship, I am relying in. Paragraph 3, 5, then 12, 13.
Hmm.
Then the last two paragraphs, paragraph 35 Lordship. Paragraph 35 and 38.
So many paragraphs.
Yes, Lordship. Because here,
Then other case,
here in the other case, Lordship, this
2018.
yes, 2018, 1 SCC 797, Union Territory of Chandigarh versus Pradeep Kumar and another Lordship. Lordship, here I am relying on the paragraphs 5, 7, 10, 11, and the paragraph 17, Lordship.
This is
Here all these
honorable
involving.
acquittal.
Yes, Lordship, their acquittal is there. They have admitted also, Lordship. They have furnished a affidavit clarifying their involvement, Lordship. But even then also they were acquitted. Their authorities, the Supreme Court has decided, Lordship, that because they have emphasized on the Meher Singh case, Lordship, in the case in hand, there is nothing to suggest that the decision of the screening committee is mala fide.
No, in this 2018, the Meher Singh is also been.
Yes, Lordship. In
Court had
2000
relied.
yes, Meher Singh has been relied, Lordship, where no interference has been. High Court considered the case of the petitioner's Lordship, but subsequently this has been set aside and this was upheld by the Honorable Supreme Court, Lordship, in both this. Because it is mentioned that regarding the service in the police, Lordship.
We'll limit ourselves to the High Court. Then Honorable Supreme Court will see. All right.
So these are all involving appointment in the police force, Lordship.
Meher Singh.
And
Yes.
Lordship, one more thing, just I want to, Section 58 of the Evidence Act is clear, Lordship. When there is admission of guilt, Lordship, no further inquiry it is required, Lordship.
All right, that is
Now,
something different.
from disciplinary proceedings, yes, skipping to the.
And there is no whisper regarding the procedural lapse and anything in the pleading itself, Lordship.
Okay, that's all.
Lordship.
Heard Mr.
Jay Kalita.
Jay Kalita, counsel for the petitioner, and also heard Miss MS and M. Bhattacharjee. Bhattacharjee or Bhattacharya?
Yes, Lordship.
Bhattacharjee, London State Council for respondents. Challenge made next para. Made in district petition is today. Order dated 09/02/2024. Where it is?
At page 42.
40?
Two.
Issued by the Superintendent of Police within brackets COMMN. What is this? Communication.
Communication.
COMMN, comma, Assam. Whereby the petitioner is terminated from the service as constable.
Constable.
What is constable? WO/WT, comma, of APRO with immediate effect. We pass the order. Let me see whether I can finish today. If not, I'll see whether maybe CAB.
Lordship.
Let's see. whoever time on this is, make it CL. Let us see.
Obliged.
Please, your lordship.
Yes.
My lord, the matter relates to the pension of the petitioners.
Hmm.
The petitioners were, my lord, serving in the Oil India Limited and subsequently they retired. Petitioners' claim is that, my lord, they are entitled to pension as per the existing old pension scheme.
Hmm.
Whereas they have been denied that scheme, my lord.
Hmm.
My lord, so what had happened is, my lord, that petitioners were appointed prior to nationalization of Oil India, my lord. Oil India Limited was nationalized through an Acquisition Act in 14/10/1981, and the petitioners had, prior to that date, appointed as graduate engineer trainees. And since their date of appointment, my lord, they've been their seniority, their provident fund, everything has been deducted from the date of the initial appointment. And subsequently, after the Acquisition Act, also they have continued to serve. My lord, as per the Acquisition Act, Section 11 says that all the employees will be transferred to the new company. And Section 12 says, my lord, all the provident fund and all superannuation benefit funds that were there in the old company would be transferred to the new company. Pursuant to that, my lord, Oil India Company has established their own provident pension fund in 1982, in August of 1982. And my lord, in the provident fund rules, in Rule 8, it states that all persons who are members of the old fund will continue to be the members of the new fund. Thereafter, my lord, in 1983, the company has brought out a rationalization of pay letter that was circulated. In the rationalization of pay, my lord, it was stated that provident fund will remain the same, and for all members who were already members of the existing fund, they will receive pension, but for future members will not receive pension, my lord.
Yes.
My lord. Subsequently, my lord, the petitioners have continued to serve. They have been in 1996. They received the roles of persons who were members of the provident fund, a pension fund, in which the petitioner's name have appeared. Then, my lord, some of the petitioners had sought for voluntary retirement in 1991, which was also denied because they were members of the provident fund, pension fund. So, my lord, the petitioners were always under the impression that they are members of the pension fund. However, when the petitioner number 12 was about to retire, then suddenly they came to know that they are being rejected under the under the old pension scheme. They have been stated that they were not members, they were not employees of the company in 1981, so they will not receive the pension under the old pension scheme, my lord. So we have challenged that. After filing of the first writ petition, my lord, item number 9, 3175, the board of directors have then come up and rejected the claim of the petitioners. Representations were made, that was rejected, and subsequently we have filed the item number 8.
Against the rejection.
My lord, it has been rejected.
Initially, when you filed this item
No, my lord,
8,
there was
there
nothing.
was no rejection.
There was no rejection, my lord.
Thereafter, when it was rejected,
Yes, my lord.
then you filed this.
My lord,
subsequently.
prior to that rejection, there was no opportunity granted to us. Nothing was provided to us to state that we are not members. In fact, my lord, as I've stated, my lord, 1983, the rationalization of pay letter, we were under the impression that since we are members of the existing fund, we'll be members of the new fund, and we have continued to serve. My lord, in this regard, my lord, it is to be noted, they are claiming that we are apprentices. We were appointed as apprentices, and therefore we are not eligible to be members. We are not employees of the company. But my lord, Apprentice Act states that the company has no obligation to pay any superannuation benefits or to consider them for continuous employment. But my lord, the company has, on its own volition, deducted our pension fund under the Pension Fund Act. And as per the Pension Fund Act, if our pension is being deducted, if our provident fund is being deducted, we are employees. And my lord, the rules of the erstwhile company, provident fund, pension fund rules, the pension fund rule says that once our provident fund is deducted, we are considered members of the old pension fund. So, my lord, on the date on which our provident fund was deducted, we automatically became members of the new pension fund. We are also members of the provident fund, and accordingly, our pension fund should have been considered for a new pension fund also, my lord. That is our case, my lord, in brief.
Yes.
And my lord, they have not denied that the deductions in provident fund was not made. They have not even denied that, my lord. So it is a fact that we are continuous members of the of the provident fund was deducted, and we have been employees of the company since prior to the acquisition. So subsequently, my lord, without any notice, without any hearing, we have been they have now stated that we are not members of the pension fund, my lord, and they have used our benefits.
Where
That is
it
our
is,
case.
where it is,
My lord,
where it is,
which part, my lord?
that rejection.
My lord, it's in the affidavit in opposition. My lord may take up item number 9 first, my lord.
Huh.
In annexure number 8, my lord, there. Page, my lord, let me give me one moment. I apologize, my lord, may check the other writ petition, my lord, because of the paginations, I have kind of missed out on that. It's in the writ petition itself, my lord, 5845 2017.
You said rejection, after rejection, you filed a subsequent writ petition.
My lord, that is 5845 2017. We have filed this.
Okay.
My lord, may see the last page of the writ petition, 100, 101, all of those annexures we have annexed, my lord. Request for pension under Oil India for pension fund.
Not request,
Yes, sir.
rejection of your claim.
Under this, it has been rejected, my lord.
100.
My lord, 100, page number 100, my lord, may see.
Ah.
Sri Prasanta Kumar Kalita, he is one of the petitioners. If I may read, my lord. Subject request for pension under Oil India Pension Fund. Dear sir, this refers to the representation claiming pension under the Oil India Pension Fund. The matter was considered by the Board of Directors of Oil India. The board considered the facts related to the matter including that on the appointed date of nationalization of Oil India, you were neither an employee of the Oil India nor a member of the Burma Oil India Company Pension Fund. Any appointment in Oil India Limited was after nationalization of the company on the specific condition that your appointment would be subject to conditions of service for the executive cadre decided by the company post nationalization. The board observed that in this behalf that the policy decision taken by the company in consultation with Government of India for post-nationalization appointments specifically stipulated that pension under the Oil India Pension Fund scheme would be available only to executives on the roll of the company on the appointed day of the nationalization, and the persons appointed post-nationalization will not be entitled to pension under the pension scheme. This was circulated for communication to all executives by so-and-so, dated 1983. This is the rationalization of pay letter, my lord, and was acknowledged by the executives. The board accordingly decided that you would not be entitled to pension under the Oil India Pension Fund applicable to pre-nationalization employees. Your appeal is being disposed of with approval of the board. My lord. The fact is, my lord, the petitioners were appointed as graduate engineer trainees prior to nationalization. And my lord, as per that, we have continued to act, and the company has been deducting our provident fund, and our provident fund has been
You said you were neither the employee nor
No, madam, that is
member
not
of the Burma Oil Company, and your appointment in Oil India was after nationalization of the company.
My lord, may take up the affidavit in opposition they have filed. We have all been appointed prior to the nationalization. In fact, my lord,
Then why they are saying that your appointment was after nationalization?
my lord, because their claim is that our appointment as graduate engineer trainees, we are apprentices. We are not employees.
And thereafter any appointment
My lord, then we have been then confirmed as executives. We have continued to
after
serve
the nationalization.
after the nationalization. My lord, the point is, my lord, as per the Acquisition Act, there is no division between a permanent, a trainee. There is the term that is used is whole-time officer and other employees. It's
Where
an
is that
inclusive
confirmation.
But,
Initial appointment.
initial appointment, my lord. Initial appointment is there in the
Or as
affidavit,
a this thing.
my lord. As
Not
graduate
as a
engineer,
apprenticeship, not as a regular employment.
my lord, that is there in the affidavit in opposition. My lord, may take up the first writ petition. It's in the respondents R7, my lord. Annexure R7 of the affidavit no opposition.
Again, another writ petition.
My lord, the first one I have
5845.
3175, my lord.
Three one seven. Page.
My lord, it's in R7 of the affidavit in opposition, my lord.
Sir, tell us the running page.
My lord, it's in internal page number, my lord.
Running page.
My lord, just my lord, give me a second. My lord, page number 153.
Yes.
My lord, this is for one of the petitioners, D. Gogoi.
1983.
My lord,
82.
1982.
Ah.
Appointment as drilling engineer.
When was the
acquisition was in 81, my lord.
then?
My lord, the fact is, my lord, they were still
The
employees.
appointment is effective from June 25, 1982.
My lord, but my lord may come to annex.
Which date you will receive a basic salary, so and so. You have accepted this.
My lord, it is true, my lord. But the fact is, my lord, we have been, however, appointed.
How you are entitled? If you are appointed after the.
My lord, because my lord may take up I'll come to the page number, my lord.
Just tell us first. We'll
My
go
lord,
to the
because
paper.
our provident fund has been deducted, my lord. They may say that we are they may say that we were trainees, but once our provident fund is deducted, as per their own Burma Oil India Pension Fund original existing fund rules, we become members of the fund. Their own subsequent fund rules says that once we are members of the existing fund, we automatically become members of the new fund, my lord.
What does it say?
My lord may see first, my lord, the old existing pension fund rules. It's in the affidavit in reply that we have filed. It's in 323. Page number 329, my lord may come.
329.
Well, this is the Burma Oil Pension Rule as it existed in 1980-81, my lord, prior to the acquisition. The following employees shall be members of the fund. Persons who entered into a specific category of service with the company as detailed hereinafter the 1st of January 1973 and who are members of the Burma Oil India Provident Fund or Provident and Insurance Fund. So, my lord, we were members of the Provident Fund.
It's okay. This is during this Burma oil pension rules.
My lord, this is the rules, my lord, because subsequently, while filing the writ petition, we have sought for an RTI to get the complete copy of the rules that was not provided, my lord.
No, that we are not concerned. I cannot.
This is the Provident Fund. This is the pension fund rules.
Pension will be granted to a member or retirement from the service at or after normal pension is provided at any time of such retirement. Yes. No, this is of 1980-81. Is it applies to the
My lord, because subsequently
All
this,
India?
my lord, this applies because
How?
subsequently, my lord may come to the writ petition, the new fund that they have created, Oil India Pension Fund, that is in 1982.
Which page?
Well, it starts at page number 22. My lord may come to Rule 8 of it. Rule 8 is in
Page 22 of
the writ petition, my lord.
this writ petition.
3175, my lord.
Huh?
3175.
3175.
Rule 8 is in page number 35.
Yes. Yes.
Part 3 membership, my lord. Rule page number 35.
35 or 25?
It's a continuation, my lord. I'm coming to page number 35.
35.
Part 3 membership.
Huh?
Yes. Part 3 membership, my lord. Rule 8 states, 8A states, employees who are members of the existing fund will automatically be admitted to the membership of the fund. So, my lord, since we were members of the existing fund, considering that
employees who are the members of the existing fund will automatically be admitted to the members of the fund.
A new fund of this fund.
What is existing fund?
Well, existing fund is the Burma Oil India Pension Fund.
Employee of the company as on 14/1980 who was not a member of the existing fund but was otherwise eligible for confirmation for membership under the rules of the existing fund. Make an application trustee in such form as they would be able to prescribe the trustees and such. Very difficult to find out employees who are the members of the existing fund. What is the existing fund? Which
Well, existing fund is the Burma Oil India Pension Fund. That was the company that existed, my lord.
accordingly?
According
to you.
No, my lord. Prior to 14/10/1981, Oil India existed as Burma Oil India Company. So, my lord, there they had a pension fund. After acquisition, my lord, all the funds from that fund was transferred to the Oil India Pension Fund, and the Acquisition Act stated that
Thereafter, this rule was made.
the rule was made, my lord.
It was framed, and therefore the existing fund.
Members of the
Means-
existing fund will become members of the new.
The existing fund means that earlier
Earlier Burma Oil India Pension Fund.
Burma Pension
My lord,
Fund.
that I have shown, my lord, how to become a member of the existing fund. So, my lord, once they are member of the existing fund, my lord, they should automatically be considered as members of the new fund. So that is why, my lord, the petitioners and my lord, since night.
So according to you, you have contributed, there was a deduction.
Yes, my lord, Provident Fund deductions were continuous.
As a trainee.
Yes, my lord. And
How it was possible?
and upon retirement, my lord,
How it was possible,
that
sir?
is what, my lord, they have in
Because
their
you were
benevolence.
appointed with effect from 1982.
No, my lord, we are appointed as graduate engineer trainees.
Okay, there were, what they are saying, but then why this appointment is?
My lord may see page number 125 of the
Ah.
affidavit in opposition. Those contain our appointment as graduate engineer trainees, my lord.
So it was with effect from 1982.
No, my lord, that is as executives. As our trainees, it has been pre-1981.
Trainees too, this cannot be said to be an appointment.
My lord,
It's not in the joke kind of thing. It's a trainee, you are trainee.
my lord, that is in the nature of the contract, it is, they have used the word trainee, but our nature of work was that of a permanent employee. Therefore, my lord, we were given salary slips, we were not given stipends, we were given salary slips. Our provident fund deductions were made.
Stipend and salaries are different thing.
Yes, my lord, that's why we were paid
Different,
salaries though, my lord.
Connotation, different meaning and different concept.
Exactly. However, my lord, we are still being paid salaries, my lord. And our provident fund deductions were made.
And how you were appointed again in 1982?
So that was a confirmation, my lord. The nature is of a confirmation.
It doesn't say.
My lord, the word the word appointment is used so that we can be denied this benefit, my lord.
No. I mean,
It should not have.
How cunning they could be.
That is
Your
the-
employer, no, nothing is.
My lord, I humbly submit, my lord, that since we have never been informed, in fact, my lord, we have
So you have appointed by this letter,
no, my lord, our appointment is
clearly
initially,
showing that your appointments will be effective from so and so the 1982.
my lord, may come to page number 126 for a moment, my lord. In page number 126, those are appointment as graduate engineer trainees. And once we have been appointed, my lord, the acquisition
No,
act,
that's what I understand. As a trainee, you have been appointed, but
Well-
then what about this appointment in the?
that is a continuation, my lord.
No, it doesn't say. You read that appointment.
I,
Page 1, the appointment as graduate engineer trainee.
my lord,
Yes. First year of your appointment will be governed by the apprentices.
apprenticeship act, my lord.
The continuation of training up to the first 12 months will depend on your performance during that period. Nearer completion of total so
So, my lord, these are all
subject
in
to
1980.
qualifying to test. Refer to the paragraph above and the subject to. If you qualify in the test, refer to other field. You cannot be
Well-
absorbed due to lack of suitable vacancies. You will continue with your training. It's the appointment on trainee,
My lord, these are all
as a trainee.
exactly, my lord. We have been appointed as trainees prior to 1981, my lord, or prior to the date of acquisition of the company, my lord.
Hmm.
And I may draw my lord's attention to the Acquisition Act. This is, my lord, the Acquisition Act through which Oil India was acquired.
Hmm.
My lord, it's in page number 221. It starts from page number
21.
My lord, it's an affidavit in reply, my lord. We have annexed the entire act. Let me come to section 11 in 226. My lord, it says provisions relating to its employees. Section 11, transfer of service of existing employees of the specified companies. Number one, every whole-time officer or other employee, those are the only two categories, my lord, of a specified company who was immediately before the appointed date employed by that company in connection with its undertakings in India, and every whole-time officer or other employee of a specified company who was immediately before the appointed date temporarily holding any assignment outside India shall on the appointed day become an officer or other employee as the case may be of the central government or the conserved government company, herein referred to as the successor government company, in which the right title interest of the specified company in relation to the undertakings in India have been vested under this act and shall hold office so and so manner. So, my lord, there are only two categories. Either you are a whole-time officer or other employees. It's an inclusive term, my lord, to protect the services of all persons who were then holding before and then in the subsequently after the acquisition.
Transfer of service of existing employees of the specified companies. Every whole-time officer or other employee of a specific company. What is this specified company?
Well, specified companies from the Burma Oil India Company to the Oil India Company, the new the government acquisition, my lord. It's defined under the act itself.
Specified company means Burma India.
No, my lord, specified company means a company defined in clause H. It's either the Oil India Company or the Burma Oil India Company. So, my lord, the specified company in this context means the Burma Oil India Company.
Any formal order transferring your service?
No, my lord. No, my lord. Under this act, it has automatically been transferred. No communication has been made because the purpose of section 11, if I may submit, my lord, was to preserve the employment status.
Yeah, I have understood, but then how you initially you were appointed on trainee, but then subsequently after transfer you after the acquisition,
my lord,
you have been appointed.
Well, we have continued as trainee for a period and then we have been appointed. My lord, may also
Just show the appointment order. Does it say anything?
As graduate engineer trainees, my lord.
Whatever the appointment in 1982.
1982. Well, appointment in 1982 does
that you appointed, you having been appointed as trainee,
my lord,
will continue, and on that basis your appointment, you are appointed in that.
Well, may consider that our promotion, seniority, our provident funds have all been calculated since our initial date of graduate engineer trainees. And
no, I'm asking in the appointment order of 1982, is there anything to indicate that you are appointed during, I mean, in the Burma Oil India, and you are allowed to continue?
Well, that is contained in the graduate engineer trainee appointment, my lord. Subsequent to that, we have been confirmed as executive engineer trainees. There is no break in service, my lord.
That's what I'm saying. Is there any indication?
Indication where, my lord?
In the appointment order 1982.
The 82 82 appointment does not consider specifically any reference to the appointment, my lord. But my lord may still consider that as per the Acquisition Act section 12 also, my lord, it states that if I may read, my lord, section 12 of the Acquisition Act, where a provident superannuation welfare or other fund has been established by a specified company for the benefit of persons employed by it in connection with its undertakings in India or for the benefit of such persons employed by All India, the monies relatable to the employees whose services are transferred by or under this act to the central government or successor company, or as the case may be, continued in All India, or who are in receipt of pension or pensionary benefits before the appointment day, shall out of the money standing on that date to credit of such provident superannuation welfare or other fund stand transferred and vested on the central government. So, my lord, it is not denied that our provident funds have been transferred, our gratuity have stood transferred. So, my lord, how is it possible that only deductions that were made by Burma Oil India Company in the pension fund has not stood transferred, my lord? Superannuation funds, all superannuation funds must have stood transferred, my lord. As
No, no, that's what I've understood, but then problem is that it doesn't show that your appointment is in continuation or it's a kind of confirmation.
Well,
Being a trainee in the other company, a Burma company.
well, there is no break-in service of any employees, my lord,
Oh.
any of the petitioners, my lord.
Oh.
My lord, may seek a clarification from the company if it is required. But it, as far as the information
Your
I have,
initial appointment is from the,
from graduate engineer training, my lord,
when it was?
prior to the acquisition, my lord,
When?
1980 and 81.
Yeah.
But in
Prior
the
to the acquisition.
my lord,
Prior to the acquisition.
prior to the acquisition, my lord,
Then your appointment as in the substantive is in 1982.
my lord.
How it's possible?
My lord, because it says that,
Were you appointed being a trainee?
yes, my lord, we are appointed as trainees. We have worked as
No,
trainees.
no, after that.
After what, my lord? After the acquisition.
Huh?
Yes, my lord, we have continued.
It's not a continuation. Whether your appointment is based on your having been appointed as a trainee.
Yes, my lord, this is a,
How? That's why I'm saying you just show us from the appointment order.
my lord may see,
Been appointed on having been earlier appointed and continued as a trainee.
my lord. My lord may come,
Then it may
My-
bridge the, I mean, the link.
my lord may see,
You're simply saying that you have continued, you are not, unless it's this appointment order
my lord.
reflects.
My lord may come to page number 143. So what had happened, my lord? After graduate engineer trainees, people were not completing the trainee and they were leaving the company because of low stipends. Then the board of directors had a meeting and they decided that we have to extend benefits to the graduate engineer trainees so that with higher pay, so that they continue in the company. And my lord, we signed the bond saying that we'll serve three years in the company after completion of our training. So we have signed the bond, we have worked with the company, my lord.
It's okay, nobody is disputing. I'm
Well-
saying that what's the link between your trainee and the appointment, eventual appointment?
My lord,
Eventual appointment as a, whatever in 1982.
as executives, my lord.
You
My lord,
you
may,
just saw the bridge and the link between your appointment as a trainee and appointment as
my
a
lord may come to
executive.
page number 143, my lord.
Yes,
My lord, executive trainee scheme.
we're not concerned.
My lord, this says that it extends the benefits of this scheme to all existing graduate engineer trainees.
Who is disputing this?
My lord, so these are the same persons we have signed executive trainee schemes.
That's what I'm saying. You were appointed as a trainee
My lord,
before the amalgam, I mean the what is it called, acquisition.
my lord.
And then thereafter you were appointed as an executive
Yes, my lord.
in 1982.
My lord.
What is the link between these trainee appointment and your new appointment,
My lord, trainee appointments.
subsequent appointment?
Trainee appointments are is sort of a feeder cadre, my lord. So you have to undergo
Show us. That's what I'm saying.
if my lord me.
That will be indicated or somewhere in the, I mean, memorandum or something like that, decision, whatever.
My lord, I may show the roles of the employees, my lord. If in the writ petition page number 52.
Yes, you are. 52.
52, my lord.
What does it do?
It is a list of employees and it shows the joining date of the employees when they were initially appointed as per the company.
So you link with this appointment order in 1982, please.
No, my lord, this is one in 1996 when they were already executives.
Huh?
This is in this this list is of 1996
Hmm.
when the petitioners were already executives.
Hmm.
But their joining date is considered from their initial appointment as graduate engineer trainees.
Hmm. Yes.
So, my lord, this shows that we were continuing as graduate engineer trainees, then we were appointed as executives, and we have continued in service. There's no break or there's no separate initiation of service that has happened in 1989.
Then when you were allowed to retire?
My lord, they have retired on different dates. In 2017, the first writ petitioner,
Passing the date of appointment in 1981?
1980 and 81, my lord. These are the petitioners. All have been appointed in 1980 or 1981, my lord.
Hmm.
And subsequently, they have retired in 2000.
Based on this, the appointment.
They have, my lord, they have retired in.
Not appointment.
My lord,
Yes.
they have retired in 2017 to 19 period, my lord. They have
Hmm.
retired.
All India Limited list of pensionable executives as of November 1996. It's okay, what I'm trying to do. No, this is your appointment in 1982
My lord.
and your appointment as a trainee, where is there any link? Although this is shown that you have been, it appears that your joining as a trainee has been calculated
My lord.
as a joining date. It doesn't show anything about.
My lord, may give me 1 day's time. I'll go through and find out if there's anything if it's
Uh,
available, my lord. My lord, fix it tomorrow, my lord.
When,
Let me just go
30
through.
minutes.
I understand, my lord. Let me just give me 1 day's opportunity. Or my lord, may fix it at 2. I'll go through the documents and see if I can find something in that regard.
So according to you, since you are appointed
my lord,
prior to
my lord,
uh, acquisition
my lord.
and the moment, even after the acquisition, as per this act and rules, since you are appointed, although maybe in the trainee,
As a
continue to your
My lord.
service, and then automatically your service is transferred to the All India.
All India.
Therefore, the funds,
My lord.
what fund is called?
The
Pension fund.
pension fund, my lord.
Pension funds, as per this act and rules,
My lord. It's too transferred.
you
my
are
lord.
entitled.
And since we are members of the existing pension fund,
Otherwise, if your appointment is taken and your this appointment, your fresh appointment or the subsequent appointment as an executive is taken, obviously you
My
will
lord.
not be entitled.
my lord, if I may
No, no,
ask, my lord, my lord, I understand. Is my
Assuming
lord's,
that your
is my
appointment is in 1982.
82. If it's a fresh appointment,
Fresh
if
appointment,
there is
you
no
will not-
connection with the other
Yes.
one, my lord is.
That is what that you have to connect.
My lord. Is my
Yeah,
lord.
though the appointment is, because it says that from the date you appointed, from the date of so and so, certain specific date in 1982,
My lord,
right?
my lord.
Maybe from the date of appointment, date of order,
My lord.
appointment order, but it doesn't indicate, of course, subject to what the other, the conditions
My lord.
prescribed therein.
I'll go
We
through
have not gone into it,
my lord,
but then unless you can connect
my lord,
that your appointment in 1980 and 81
my lord. Well,
has a bearing and it has been continued,
I'll
on the
understand.
basis of which you have been provided an opportunity
I
by way of upgradation or promotion, whatever,
My lord.
as an executive.
My lord,
Otherwise, it's very difficult.
I'll find out the document
to
because my
link.
lord, that was never a contention raised by the company, my lord. They have not stated
That
that
is
from
the
graduate.
assets.
I understand, my lord. I
Is not it, sir?
understand. My lord.
This is the, I mean, this is the actual thing. I mean, this is the main thing. That unless he has been appointed in 1982 after the acquisition, he said he was appointed as a trainee, no matter as a trainee also, but he continues. But the act after the acquisition, which provides that the services will be transferred to the new, I mean, distributed company, that's All India. Therefore, since as a trainee, there was a deduction and the contributory function were deducted, it goes merged with, goes with the services. Is not it?
My lord.
So unless there is a link between the appointment as a trainee prior to the acquisition and thereafter the new, I mean, eventual appointment as an executive, whatever, is shown. In other words, if the appointment is shown that the eventual appointment as an executive after the acquisition is shown on the basis or the connection with the appointment as a trainee prior to the acquisition,
My lord.
it will be difficult to, I mean,
My lord, your lordship has correctly put the question, my lord. For that for clarification, only two documents need to be seen.
Hmm.
One is the appointment as trainee, and one is the appointment after acquisition as my lord executive. These are the two documents to be seen.
yes.
May I draw your lordship's attention, my lord? If your lordship kindly takes up my additional
And in
affidavit.
fact, he is asking for 1 day.
My lord, thank you.
So in that case, not 1 day, we'll keep it part heart. We'll hear, we'll hear you for some time on the next day. And then we'll hear them.
My lord,
We'll develop the plan, the senior counsel. And it's better to, better to file a written submission.
that we have submitted, my
In
lord.
fact, my lord, we have already submitted our written argument, my lord.
Is it?
Yes, my lord. It is there on record. Your lordship may kindly peruse, and my lord, these documents should make the, my lord, clear the queries that your lordship has raised, my lord. Yes, my lord, after the acquisition, there was, my lord, fresh advertisement, there was a fresh selection. After that selection, they were appointed as executives. That is not true, my lord. That is what
Okay. It was released better.
Yes, my lord.
So I'll show your lordship that, my lord, this is a fresh selection. After the acquisition, my lord, fresh selection by fresh advertisement, fresh selection process. Thereafter, they were appointed as executives in
Yes, sure.
1982.
Okay, we'll hear them in that case.
My lord.
You want to make,
My lord, I'll just make one submission, my lord. Irrespective of that, my lord, if our provident fund is being deducted and we are members of the provident fund, if our service is continuous and they have not terminated us, we are members of the new fund. That cannot be denied, my lord. Since we are member of the old fund, as per their own rules, we are members of the new fund. So how is it possible that
so that's what I'm saying. If
Even-
that is the case,
yes, my lord, since
if
our
that is
provident
the,
fund is,
if that is the case,
my lord,
I mean, again, I've asked.
I
you-
understand, ma'am.
You
well, since our
put a
provident fund
link
is,
between the initial appointment as a trainee and the appointment, eventual appointment as an
but our
executive.
provident fund is calculated from our initial date. If there was a break in service, it would not have been calculated from
It's
that.
okay, that I've understood, but you have to show that by documents.
Well, I'll try and,
I'll answer that,
So
my lord.
now-
I'll answer it.
Now
on-
hear him, we'll
Yes.
hear. Now
My
we'll
lord,
hear
I'll
him.
answer that, but my lord, it's not that they are not getting anything. They have been receiving pension. They want in the higher scale, higher rate, my lord. That
what
is
we
the
are
case.
entitled.
That has
my
not
lord.
been
We are-
submitted.
We are entitled.
Listen, we'll hear him now.
My lord, may fix it on another date, my lord.
No, today will complete.
My lord, the case that I am forwarding is, my lord, if our provident fund, if our service is continuous, there is no denying the fact that our service is continuous, my lord. We have not stopped at any point being employees of the employees of Oil India, my lord. They might have been trying to make an artificial break for the purpose of denying us some service, but my lord, it is undeniable that our service has continued pre-nationalization. And my lord, to that effect, my lord may come to see. There's a copy of the provident fund that we have annexed, my lord, that deduction that we have annexed. My lord, we see that also, my lord. It's in page number 248, my lord, of the affidavit in reply. First come. My lord, may see 248, my lord.
Yes.
In page number 248, on the top left-hand side, it says Oil, Burma Oil India SR Fund. And these are the PF deductions, my lord. And it says statements from April 1981 to 13th October 1981. Then my lord may come to the next page. This is statement from 14 October 1981 till 1982. Just the date of, one is prior to the date of acquisition, one is subsequent to the date of acquisition. These are the pension funds, my lord. Oil India, this is Oil EMP Fund. So my lord, The pension fund, provident fund has been transferred. There is no denying that, madam. And upon our retirement, our provident fund has been calculated from our initial date, since it was being since our appointment as graduate engineer trainees. Our provident fund has been calculated. So, my lord, if our provident fund is deducted, then we are already members of the Burma Oil India Pension Fund, and as per their own rules, we must be members of the new fund.
So how much you have been paid?
My lord,
Have you received the pension?
they have, my lord, filed an affidavit. No, my lord, we have not accepted. A few of the petitioners have accepted, but majority of the petitioners have not accepted, my lord.
How it was calculated, minus those period of?
No, my lord, they have floated a new scheme in 2007.
Ah,
In 2007, and which we were never intimated about that we will be covered under this. Only when our rejection was done and when our retirements happened, we were saying that you will be entitled only under the new fund and not under the existing fund, or under the Burma Oil India Fund. They have made a table, my lord, in page number 324 of the affidavit of opposition that they have filed. Additional affidavit, my lord.
324.
322, my lord. 322. It's 322, my lord. Now, these two petitioners have taken, have made withdrawals under the new pension fund.
Pension payable by respondent no one.
Right.
Yes.
The rest have not.
This is based on?
This is based on the, my lord, the new pension scheme that they were eligible under. The OIEPF, my lord. My lord may see, OIEPF. This, no, my lord may see the first name, oil ID, DOR, Provident Fund, gratuity, EPS 95, OIS BSF. This OIS BSF is the new pension fund, my lord. That was introduced in 2007. My lord, for gratuity, Provident Fund, EPF 95, 1995, those are all calculated from the appointment as graduate engineer trainees.
So what was the existing fund?
The existing fund, my lord, I have shown you Rule 8, my lord, that is there. That is the existing fund that would have been transferred from the Burma Oil India Pension Fund to the new fund.
So according to you, how
We are-
much would be the
No,
difference?
we don't have the calculations. I don't have the calculations about that, my lord.
So we must know.
According to their
it must be,
calculations, well, according to their
it must be a huge amount.
I have no, I am not privy to that information, my lord. I have not sought that information from the.
No, once it is, if you are held to be entitled under that existing fund,
My lord.
what would be the difference? That I just.
But there will be a difference, my lord. I've been told there will be a difference, but I'm not aware about what would be the
This
exact.
serial number 6 and 7, they have received it.
No, my lord. This is the 6 and 7 is the for the EPF, my lord. I think for 6 and 8, 6 and 8 have received it, my lord.
They have received.
Well, the rest are in
Rangago is
progress.
the petitioner number 1, right?
My lord, my lord.
You have received it.
That would not perhaps reason to deny that if they have a legitimate due, my lord.
Yes.
So, my lord, my prayer is, my lord, since they have been employees, if artificial breaks are made in their services, that would not deny them, because as per the Provident Fund Act, you require to be an employee under the Provident employee to be for deductions under the Provident Fund. If, my lord, our fresh appointments were made prior post nationalization, we would not have received the Provident Fund from the initial dates, my lord. And, my lord, there cannot be piecemeal transfers of funds. The Burma Oil India Company, prior to acquisition, must have transferred some of our funds back to the Oil India Company for into this new fund, because the deduction that the company has to make to the Provident Fund into the pension fund is annual. So, my lord, on which date was the decision made that for our petitioners, we will not make the deductions? Was it after acquisition, after the rationalization of pay letter? Because in 1996, the rules show that our names are there in the pension list. In 2007 list, it shows that our names are in the pension list. When was the decision made that we are not entitled to the pension, my lord?
2006.
No idea, my lord. Because 2007 this has come, so prior to that some intimation must have been made. Looking for clarifications.
They will continue it.
Well,
My lord, sorry, my lord, item number 5, my lord.
We'll
Can I-
continue at 2.
My lord, I have some personal difficulty, my lord. I have to-
Personal difficulty.
But I have to go to home, my lord. Some call has come.
What are better?
My lord, on Thursday, my lord.
I've heard you.
My lord, I have, my lord, prepared a bunch of judgments, my lord. I will rely on that, my lord.
You let your juniors be here.
My
Please.
lord, they may not be, no, Thursday, my lord, Thursday, I will just take 10-15 minutes, my lord. I would have done today, but some call has come, my lord.
5 and 6. 5 and 6.
5 and 6 will be fine.
Mr. Air Buya, Land Council for the petitioners. Submits that he has an
Margin.
emergent call from the emergent call which he had to attend.
Margin.
Therefore, praise for listing of the matter.
Your lordship,
On Thursday.
Thursday,
not in
20,
5 and 6.
11:20. Consider above.
your lordship,
Oblige.
for a small your lordship for item number 10 and 11.
No, you wait for your turn.
Oh.
10 and 11. All right,
Okay.
we'll continue.
Jalan on behalf of the respondent bank, SBI.
I appear for the petitioner, lordship.
Yes, no objection.
G. Jalan, London Council, Mr. G. Jalan, London Council for the London Council submits that he has been engaged recently in this matter. Therefore, praise for listing of the matter up to 4 weeks.
Yes, ma'am. Deeply obliged, ma'am.
Mr. So and so,
Mr. Amdas, for the petitioner.
London Council for the petitioner is present. Regular advertisement.
Deeply obliged.
List after 4 weeks.
Your worship. My lord, regarding, my lord had raised the issue regarding any document to show that there has been continuation in the service. My lord, in the advertisement, it has been noted that upon completion of the training period, they would be selected in the as probationers of executive cadre. My lord, may come to page number 244. Affidavit in reply.
Page?
244.
244
44, my lord.
of
3175.
P1.
75. 3175. Item number 11. 3175. 244. This is type copy. 244. 244. May I read, my lord?
31.
31, my lord, page number 244. May I read, my lord? My lord, it says Oil India Limited required graduate engineer trainees. Applications are invited for fresh engineering graduates to be recruited in as graduate engineer trainings in our drilling department. Applicant must have 60% so and so and so. My lord, training schedule, my lord. Next, selected candidates will be for the first 12 months of the training governed by the Apprentice Act. Subject to satisfactory performance in the training will be extended by another 6 months, after which, if they are found suitable and if appropriate vacancies occur, they may be absorbed as executive on probation. After completing 6 months as executive on probation satisfactorily, they will be confirmed as executive in grade B. There's another advertisement in the next page, my lord, 245.
So you have been appointed as executive in grade B.
My lord, we have been confirmed, my lord. We have been appointed. We have been absorbed, my lord. The word is absorbed. We have been absorbed, my lord. My lord, page number 245.
Huh?
My lord, again, training schedule. Selected candidates will be on training for 18 months. For the first 12 months of training, they will be governed by the Apprentices Act. Subject to satisfactory completion of training, and if appropriate vacancies occur, they would be put on probation as executives. After completing 6 months as executive on probation satisfactory, they will be confirmed as executives in grade B of the company. I'll come to the affidavit in opposition. Page number 100. Running page number 100, madam.
Same
Same petition. Page number 100, madam. This is the affidavit in opposition that has been filed by the respondents. Paragraph 28. Let me read. Since the respondent number 1 company had to spend considerable time and money and take considerable effort in training the apprentices come trainees, the respondent number 1 company wanted to ensure that this time, effort, and money and effort was not wasted with respect to those candidates who had successfully completed their apprenticeship come training, had qualified the written test and interview, and had been selected for appointment by the respondent number 1 company in the executive cadre against the existing vacancies. Now, the word they have used everywhere is they have been appointed and absorbed. Even in the advertisement manner, the word absorbed is used, manner. While we come to page number 123 of this comment. This is the appointment of graduate engineer trainee. Point number 4. The continue, my lord, if I may read.
No, this I've seen.
My lord, it reads
Who is the appointment?
This is the appointment, my lord.
Executive.
My lord, if I may read point number 4, my lord. The continuation of a training for the first 12 months will be dependent upon the performance during that period. Near completion of total of 18 months, a written test and interview will be held to assess your suitable absorption into the company.
No, same thing. No, that's it.
My lord, this is in the executive engineer training also, they have said that we will be absorbed. In point number 4 also, 5 also they have said you will be considered for employment in the executive cadre. Subsequently, my lord, we come to page number 61. This is the bond that we have signed subsequent to the graduate engineer training being appointed. In clause number D of the bond, they state the bond, they have to pay 5 lakhs if they refusing to serve the company or any of its subsidiaries for a minimum of 3 years on successful completion of training and being appointed as an executive on probation.
Let us see the appointment order as an executive.
As executives, my lord. My lord, may come to let's start from page number 66, my lord, may come. Page number. Let me see. Here also they have been required to then, since they have completed their executive training program, they are required to undergo probation after being selected.
Where is the page 66?
Page 66, 153, my lord. Internal page 66, my lord. I'm sorry. Yes. Annexure R7. 153. Internal page 66. Now let me see. Point number 4. You will be required to serve a probationary period of 6 months, which may extend in the discretion of the company. During the probationary period, we reserve the right to dispense with your service without notice. And number 5, on satisfactory completion of the probationary period or the extended period of probation, you will be confirmed in writing in the above post as executive. So, my lord, this is not a fresh appointment. No person has been appointed directly in the cadre of executives. There's an advertisement issued for graduate engineer trainees after completion of the graduate engineer training program, they are then absorbed, they're then confirmed or absorbed, my lord. The word absorbed is used in the advertisement as executive on probation and then executives.
Yes.
So my lord, my submission is that there are initially advertisements for executive engineer trainees. Upon completion of the training period, they are then confirmed as executive on probation and then executives. So it's a continuous process, my lord. There is no person that has ever been appointed directly as executive. There is no advertisement issued for executives. There are only advertisements issued for graduate engineer trainees, and they have stated in the bonds as well, my lord, that upon completion of the period as trainees, you will serve 3 years in the company as executives. That is a requirement of the company, man. That is my submission. Very good. Since they have been confirmed as executives, it's a continuing process, and the provident fund, I have already submitted my provident funds have been deducted since the initial date of joining. And so they are considered as employees for all purposes. And we don't know when they have decided to cancel it, consider us not as employees. It's been a much later time.
Yes.
Now, my lord, I wanted to draw your lordship's attention to two documents, my lord. My learned friend has placed, my lord, the appointment that, my lord, at page 153, appointment as, my lord, executives. If your lordship will kindly read, my learned friend has read from paragraph 4, but I will draw your lordship's attention to my lord, earlier paragraphs. Page 153 of the affidavit in opposition in 3175 of 2017. My learned friend was just reading that, my
150?
153.
Yes.
Appointment as drilling engineer. This is, my lord, addressed to G. Gogoi. We are writing with reference to your recent interview and have pleasure in appointing you as drilling engineer in executive grade B in the drilling department of the company on the following terms and conditions. Now, my lord, this makes it very clear that there is a selection. There is a selection process conducted within the, my lord, executive trainings. It's not that, my lord, it's a continuation of earlier, my lord, their graduate engineer trainee post. That is not the case. If your lordship kindly reads the appointment as graduate engineer trainee, my lord, we have filed an additional affidavit on 23/10/2019 in WPC 3175. There, my lord, their initial appointment or engagement as graduate engineer trainee, my lord, what are the conditions? Your lordship may kindly see.
Page?
Additional affidavit, my lord, page 261.
Yes.
This is, my lord, appointment as graduate engineer trainee, pipeline department,
We write with reference to the recent interview held on for recruiting graduate engineer trainees and are pleased to advise you that you have been selected for training in the technical departments of our organization for a period of 2 years. The first year of your appointment will be governed by Apprentice Amendment Act 1973, while the second year will be governed by a contract with Oil India Limited. During the period of training, you will be paid a consolidated stipend of rupees 700 per month for the first year and 750 per month for the subsequent period. The continuation of your training after the first 12 months will depend on your performance during that period. Then, nearer completion of a total 18 months training, a written test and interview will be held to assess your suitability for absorption into the company's executive cadre. This is, however, without any obligation on our part to absorb you in our organization on completion of this period of training. Then 4, subject to there being suitable vacancies, you will be considered for employment in the executive cadre of the company on probation for a period of 6 months. This is, of course, subject to you qualifying in the test preferred to you. So, my lord, it has been laid down in their engagement as graduate engineer trainee that you will be required to go for a selection process. And my lord, there was a scheme, and here, my lord, nowhere in this, my lord, there has been any mention about, my lord, any pension. So this is a, my lord, purely trainee executives who will be trained at the cost, my lord. We spend a lot of money, my lord, for training them. And therefore, subsequently, we take in, my lord, the undertaking from them that in the event they are selected, then they will be, they'll have to serve for 3 years. Then, my lord, if your lordship sees the order at page 153 that your lordship has already seen, my lord, that also reflects that, my lord, there has been a selection. So this cannot be connected with the, my lord, earlier, my lord, their engagement as executive trainee. It is connected only to the extent that by undertaking that training, you have qualified, you have been eligible to be considered for selection as executive.
But there is a connection.
The only connection is that, my lord, we have trained you. We have trained you for appearing in the selection for the executive cadre.
Now, what they are saying, as a trainee also, you have deducted.
That, my lord, we have answered that. If your lordship kindly takes our affidavit, that has not been denied. In fact, my lord, in our written argument, we have touched all these points and referred to the relevant pages also, because, my lord, we have to shift from this affidavit to that affidavit.
Where is
Now-
the relevant para? Where is the written argument?
Written argument, we have already supplied, my lord.
Past case number 3275. No, 3175. By the report as. Report as 7. Report as.
Yes. Where you have said, sir.
That matter, we have also stated in the affidavit, but that your lordship, so far as that deduction of, my lord, provident fund, that page 18, your lordship will find.
18.
Page 18, clause Roman 9. Regarding petitioner's claim for pension under OIPF on the basis of the PF deduction document by referring to paragraph 43 and 44 of the affidavit of opposition filed in WBC 58450 of 2017, it was submitted on behalf of the oil that at that time it was the practice of Oil India Limited by way of abundant caution to make statutory deductions towards provident fund and family pension from the stipend of the apprentice cum trainee, which was subsequently discontinued. Now, my lord, they will not be able to show any document by which, my lord, after the nationalization, there has been any deduction. And this has been discontinued, and this has not been, my lord, rebutted by them in any of the affidavit. In affidavit, my lord, we have clearly stated that at page 119, paragraph 43 of WPC 58450 of 2017.
Which one?
Paragraph 43, my lord, page
Oh.
119,
119.
in the affidavit in opposition in WPC 5845.
119.
My lord, 119. Paragraph, my lord. Paragraph 43, we have clearly stated that, my lord, page 119, has your lordship got it?
No, no, 119
In the affidavit in
in
opposition.
3175.
No, my lord, 5845. In fact, my lord, all these documents we have only supplied, my lord, petitioner has only supplied a few documents, and they did not even state that, my lord, they are getting the benefit under other schemes. Paragraph 43, my lord. The contents of paragraph 9 of the petition are denied as though herein specifically set forth herein and traverse. At that time, it was the practice of the respondent number 1 company by abundant caution to make statutory deductions towards provident fund and
What
family
is the
pension.
statutory deduction?
My lord.
Statutory deduction.
Yes, my lord. The provident fund is a statutory deduction, my lord. And family pension from the stipend of apprentice cum trainee. This practice was subsequently discontinued. Now, my lord, we have to, my lord, understand the difference between an apprentice and an employee, my lord. And for that, may I draw your lordship attention to the, my lord, Apprentice Act 1961. Listen to sentence. They were apprentice, my lord, and they want to say that we are a regular appointee. Apprentice Act 1961. May I draw your lordship's attention to the definition clause, section 2, small a. Apprentice means, has your lordship got it, my lord? Apprentice means a person who is undergoing apprenticeship training in pursuance of a contract of apprenticeship. Then your lordship will see the next provision, next definition. Apprenticeship training means a course of training in any industry or establishment undergone in pursuance of a contract of apprenticeship and under prescribed terms and conditions which may be different from different categories of apprentices. Then may I draw your lordship's attention to my lord section 18. Section 18, my lord, clarifies that apprentices are trainees and not workers. Save as otherwise provided in this act, every apprentice undergoing apprenticeship training in a designated trade in an establishment shall be a trainee and not a worker. And B, the provisions of any law with respect to labor shall not apply to or in relation to any such apprentice. Therefore, my lord, the attempt of the petitioners to show that the apprenticeship is a regular appointment is, my lord, contrary to this law. As, my lord, apprentice trainee, they were engaged. Then, my lord, there was a selection after the, my lord, the nationalization. Then after that selection process, they were selected as executives and appointed. Therefore, my lord, these two cannot be tagged together. And my lord, so far as the apprentice is concerned, my lord, we have relied on two decisions. So we have given in the, my lord, the written argument. I'll not take your lordship's time with that.
What about the
And your lordship will kindly see.
yes,
my
what did you do with the amount deducted?
amount deducted, if, no, my lord, that provident fund amount, my lord. The that we have stated in the affidavit that has been. In fact, my lord, there was no deduction from them that we have stated in my lord in our additional affidavit.
No, page 43, you have the statutory deduction you have made as an abundant caution.
Yes, that we have stated. No, the question is what did we do with this, this deduction? Reply, I'll come to that, my lord. Your lordship may kindly come to page 322 in my additional affidavit. 322.
Page.
So page 322, my lord. I'm sorry, my lord, of the additional affidavit. Your lordship has already seen the chart. Your lordship will see the chart again, my lord. Some of the petitioners have already drawn the benefit. So they cannot be the petitioners here, my lord.
Two of them.
In fact, my lord, if your lordship sees the chart. Six and 8. They have drawn the pension. Then, my lord, your lordship may come to the next, my lord, chart. These 4 persons, after commutation, my lord, they have also drawn the EPS 95 pension. The 4 persons. There are, my lord, 3 funds from them, from which, my lord, they are getting benefit. And some of the petitioners have taken the benefit from one scheme. Some of the petitioners have taken benefit from another scheme. And EPS is for everyone, my lord. Now, my lord, without, my lord, stating all those things, my lord, they approached and came and said that they are deprived of pension. This chart makes it very clear, my lord. They are getting the benefit. They want a higher benefit of the executives who were there, my lord, prior to nationalization. That is their case. I will take your lordship's time.
No,
much,
if
my lord.
they, prior to their nationalization, what entitled, how much they are entitled? And what
That
kind
calculation
of
is-
entitlement they?
That calculation will be there with the company, my lord,
Huh?
but there is a HRM committee meeting which says.
So prior to, my lord, nationalization, they were not entitled to any pension. Trainees, my lord, the apprentice, they are not entitled to pension, my
I
lord.
know, I know.
And my,
But that's what I'm saying, why, when it is deducted, and it has to, it is merge or transfer with the new company as per the act and rules. That's why they are not able to, what entitlement,
My
what
lord,
is the benefits you will get
my lord, as per, I mean.
as a trainee?
My lord, well, as a trainee, as my lord has seen, in the.
My lord, let me just complete, my lord, one sentence, if you may pardon.
Yeah.
My lord, I don't want to take your lordship's time anything anymore, my lord. These submissions, these are my limited submissions, and I'll implore that your lordship will read our written argument, my lord. So that, my lord, no much.
No, I just wanted to clarify.
My lord, regarding the EPF deductions post nationalization, my lord, it is there in the writ petition, my lord. In the writ petition itself, it has been annexed. My lord, may see page number. It's not in the writ petition, my lord, perhaps. It is there in, my lord, the affidavit in reply, page number 248.
In which writ petition?
3175, my lord. The my lord is looking at 3175.
One?
3175.
No, this
Page number 248, my lord.
248.
This is the PF deductions, contributions. A statement from April 1981 to 31 October 1981. And the next page, my lord, may see, right after nationalization, 14 October 1981 to 31st March 1982. So, my lord, PF deductions were made. Then, my lord, secondly, my lord, the Apprenticeship Act, my lord, may take once more.
No, you clear this first.
My lord,
So
my
if it is
provident fund
deducted,
has-
you are, according to, you are entitled to this money,
my lord, we are entitled to this money and my
whether
lord,
this has been paid or not.
This
This has been included in your,
it has not been included in the pension, but it has been included in the provident fund payments that we have to receive. But the existing,
see, once this provident fund, if it is included in a provident fund,
my lord,
which you have been already been paid,
my lord,
huh?
my lord, I
See, means since you are a trainee,
my lord.
how can this be included in the pension?
My lord, the thing is, as per the existing rules, if provident fund is deducted, we become members of the existing of the pension fund. Provident fund deductions result in according to the rules, my lord. It is not. It is the rules of the company itself, my lord. It is
Rules
not our
of what?
My lord, the earlier Burma Oil India pension fund, my lord, pension fund rules.
It's no longer here.
My lord, but the subsequent fund that was created
Burma India,
Burma Oil India Pension Fund, my lord.
All India Pension Fund.
My lord. The All India Pension Fund, which was subsequently created, was created to protect the beneficiaries of that fund, my lord. It is there in the pension fund rules.
Pension fund.
Rules, my lord. All India Pension Fund rules also provide that members of the Provident Burma Oil India Pension Fund will be protected.
Which page you have there?
My lord, it's in the writ petition, my lord.
Obviously, it will be in a page.
My lord, Rule 8 talks about the membership.
I'm not asking the rules, the provision, which page you have next?
My lord, it's in page number 14, and my lord,
14?
And page number 23 of the writ petition.
Both this Burma India and All India.
My lord,
In
All India, page number 23 is All India, which states
in the
in order to give
WPC?
3175, my lord. Now, if I may read it, my lord, whereas in order to give effect to the my lord, if I may kindly read it, my lord.
Okay.
In order to give effect to the provisions of the Acquisition Act in respect of the beneficiaries of the existing fund, or so, however, that their rights and benefits in no way are prejudiced or diminished, the company is obliged to establish the fund for purpose of providing pension in accordance with the rules of the fund appended to this trust deed to the members of the existing fund and also others.
You have read that already.
My lord. So we are members, and my lord, I may draw your lordship's attention to the Apprenticeship Act. Well, Apprenticeship Act says that the employer has no obligation. But in spite of having no obligation, if the company comes and gives us provident fund and pensions, it is not barred under the Act, my lord. The company does have the liberty to give. It says under the Act, it is not under no obligation, my lord. And this has already been provided in the written submissions that we have provided, my lord.
My lord, so far your lordship's query regarding, my lord, what happened to the deduction that has been made, that has been answered in paragraph 44 in our affidavit in opposition, my lord.
Yes.
That has been deposited to the, because my lord, provident fund doesn't have any relation with the pension. Whatever has been deducted, that is, my lord, provident fund account they have, that has been credited, and they will get credited. That is the paragraph 44.
Deductions are the provident fund.
Let me complete this sentence, please.
My lord, I apologize.
Paragraph 44 over affidavit in opposition.
Yes, I've seen it.
Provident fund deductions imply employee-employer relations, my lord. As per the Act.
When you are a trainee, admittedly, when you are a trainee.
Well, if they extend the benefits, then how can they at some point without information to us or intimation to us, then stop the benefit, my lord? There is some amount of estoppel that is created.
Okay. Any judgment you have relied?
Well, I don't have any judgment. This is a peculiar case. Only these 12 employees are under that circumstance where pre-acquisition they were engineer trainees and subsequently they have executed.
Forget it. Enjoy your evening of your life.
They have
served the company.
They have served the company, my lord. At the last moment, they are saying that we have received enough money. We are only asking for the statutory dues and the company dues that we have.
Are you getting the pension?
My lord, we are not getting the pension that we are deserving. The other pensions that my
Otherwise, you
senior has.
are getting.
No, my lord, we are getting the gratuity, the employee pension scheme pension, and the provident fund, my lord. Under this scheme, what we are supposed to be receiving, we are not receiving, my lord. Out of the 12, 10 have not accepted the new pension scheme.
Those are for the people who had served.
My lord, it is.
Not as a trainee.
It is, my lord.
As an employee.
If they have given if they have assured us.
Doesn't say that it is also for the trainee.
my lord, if they have assured us repeatedly, my
In
lord.
fact, that was the trainee apprenticeship, sorry, apprenticeship.
Apprentices,
A trainee is the backup for to get yourself employed.
My lord,
as an employee
it is true, my lord.
in the company.
But in the
It
apprentice,
says it never says that the trainee
but the
or the
apprenticeship,
apprentice.
apprenticeship act does not prohibit the
Apprenticeship also
employer.
be provided. It says the employees.
But the apprenticeship act doesn't prohibit the employer, my lord. It says the employer
see,
is
it
under no
says-
obligation.
It says that if it is,
If I may, lord, my lord, if I may draw your attention to the apprenticeship act, I'll take 1 minute, my lord.
I've seen it, yes.
Well, section 22, my lord, of the apprenticeship act. But pre-amended, it must be there, my lord. Section 22 of the apprenticeship act, 22. My lord, may see, this has been amended. I'm reading the pre-amended, my lord. It will be there in the footnotes.
22.
My lord, pre-amended, it will be there. in the-
Offer an acceptance of employment.
Offer an acceptance of, I'm reading the pre-amended, my lord, because this amendment has happened subsequently.
Hmm.
Well, pre-amended, it reads, it shall not be obligatory on the part of the employer to offer any employment to the apprentice who has completed the period of apprenticeship training in the establishment, and nor shall it be obligatory on the part of apprentice to accept. So, my lord, they have no obligation. But once they have deducted Provident Fund, we are employees under the Provident Fund Act, my lord.
It says apprentice is not a trainee, is a trainee, not worker.
It is, my lord. We are
Cannot
training.
be considered an employee.
Yes, my lord. If
When you are, even it's not a worker, you cannot be
My lord is aware,
considered as a employee.
my lord is aware, my lord, for
The employee will
apprentice.
you will be entitled if you are an employee.
My lord is
and a
aware, my lord.
worker.
Provident Fund is not deducted from employees, my lord. From trainees, my lord. My lord is aware. But if I deduct,
No, they said that it was abundant question.
it cannot be, my lord. It's a statutory deduction. They have chartered accountants who verify who are employees, who are trainees. After all verifications, they have come to this.
At best will direct you to pay those amount deducted with some interest. Isn't it?
My lord, my lord may take a decision, my lord.
No. At best, we can direct you to them to pay the amount which has been deducted with certain interest.
My lord.
At best. Anyway, we'll see.
Obliged,
We'll examine and
Obliged.
decide. Heard Mr.
R.B. Goswami, my lord.
R.B.
Goswami.
Goswami, learned counsel for the petitioners. And also heard Mr. M.K. Chaudhary, learned senior counsel, assisted by
K. Kolita.
K. Kolita, learned counsel for all the respondents. Hearing concluded, judgment reserved.
Hello.
The written submissions have already been provided.
I've seen it.
Obliged.
Your Honor, and for the BTC, we have recently received the brief. So
Where you were?
actually,
Where the brief was?
actually we have been recently engaged as a new standing
Brief
counsel.
was in the Kalapani.
No, Your Honor.
Huh?
So it requires little time, Your Honor. I have talked to.
Lordship, in the petition.
What is the matter?
Matter relating to the promotion from grade 4 to grade 3, my lord. And the petitioner in the petition in item number 10, he will be going on retired on December 20, this December, my lord. So this matter have been heard on many occasions, and every time the court directed to take instruction whether there is a vacancy position or not. So that instruction.
BTC.
Yes. So matter may be fixed on 2nd of December, my lord.
As agreed to by learned counsel for the parties, MS
A. Bujar Barua.
A. Bujar Barua, learned counsel for the petitioner, and Mr.
P. Bhomik on
P.
behalf
Bhomik,
of AK
on
Bhuiya.
behalf of AK Pukot,
AK Bhuiya,
AK Bhuiya for
BTC.
standing counsel.
Standing
BTC.
counsel.
Is it from BTC?
Yes, ABTC.
What is your ground that it should be
That
promoted?
petitioner was appointed in the year of 1994, my lord, and his service was regularized in 1999. Thereafter, this is the second time litigation, my lord. The petitioner earlier approached before this court as because the junior, a person who was junior to the petitioner, he was promoted to grade 3 post. Being aggrieved of the action of the respondent, the petitioner filed a writ petition before this court. And after hearing the matter, this honorable court disposed of the said writ petition with a direction to take necessary steps while the petitioner is left out and directed to promote it in the grade 3 post. But they are not doing, not complying with the order of the High Court, and thereafter I have filed a complaint, contempt petition. After a contempt petition, the petitioner, the respondent submitted a speaking order that where the surveillance worker, the post of surveillance.
It has been abolished.
Yes. And thereafter the petitioner, there is a selection was held, the petitioner was already been selected. Thereafter the petitioner was not promoted. Thereafter the
Not selected, you are in the,
petitioner was
you
selected.
appeared in the
Yeah, yes, selection process and his
election
name-
process. You are not.
his
you
name
could not be
appeared in the
appointed.
select list and thereafter not
You were at serial number 7.
serial number 7.
Yes.
Thereafter
So how many posts were there?
9.
9.
Nine.
So why you have not been appointed?
That is the reason before the court. And thereafter they have filed an affidavit that they are saying that the experience is required. But after long 29 years,
You are also challenging that. Why two writ petition?
both are the petition in
Different
the-
petitioners.
matter is same, but the person is 3 persons.
Okay.
Okay. Let the matter be heard on 2nd of
Second.
December. 2nd of December.
December.
And on that day, probably this matter will be. And
Yes, let's hope.
My lord, may I please, my senior legs in another court, he will come shortly. Please pass over for time being.
Possible for the day, your lordship. Yes, I have some.
What is the matter?
Matter, petitioners are all temporary, workers, your lordship. They are already terminated from service in the year 2023, your lordship. And they are claiming regularization of their services. They are not entitled, your lordship. They have filed affidavit. Pleadings are complete, your lordship.
They have been terminated.
Already terminated, your lordship, in the year 2023.
They are not challenging the termination.
Yes, your lordship, because the petition was filed earlier to the termination, your lordship. And now they have not challenged the termination.
Where is the termination?
Lordship, termination, lordship, I have filed one affidavit, your lordship.
Well.
Yes, yes, as per direction of this honorable court, that I have stated in paragraph 6 of that affidavit, that all the petitioners are terminated. And by
On behalf of respondent number 2.
2, your lordship, paragraph 6, your lordship.
There is no paragraph 6. Samsum Alam.
Yes, lordship, yes. Services of
Where it is?
paragraph 6, your lordship, additional affidavit filed by respondent number 2.
Page.
Page number 80, your lordship.
'89.
80.
Additional affidavit.
Lord, page number 127 will total, my lord. That will be, my lord, the continuous number by approximately 127, my lord.
127.
Yes, my lord. If I'm not wrong, my lord, it starts perhaps at 127. is by one, my lord.
So many additional affidavit.
Yes, my lord. That was,
The service of deliberation shows the petitioners.
All the petitioners, your lordship. I have specified in paragraph number 6, your
2,
lordship.
3, 4. Where is it? Taranath, who are the petition number 2, 3, and 4 respectively have been consequent from us and according to the addition from them. And the survey of petitioner has been disclaimed from number 2 according to his duty in the forum. Yes.
we have denied that, my lord. That's not correct because my lord, they have not given us any termination orders. It's only in the affidavit they say we have been terminated. No termination or nothing of the sort.
It's in both, your lordship.
How do we find out?
No, but I'll come to that, my lord. I will.
Once they on all
On
cases
what
there
your
has been
lordship?
affidavit terminated, how you can say that you are
I'll
terminated?
come to that, my lord. But
And this
the-
affidavit is filed as per the order of this
the
honorable
issue, but the
court.
issue here is, my lord, let us assume for a minute, I'll come to that termination part. Let us assume for a moment they've been terminated on this particular date, my lord. But they'll be entitled to the salaries prior to that date at least.
That I have, we
Well,
have admitted, your
Well,
lordship.
no, not admitted, my lord. The case is not here. The case is, these people were being given, my lord, 2,000 rupees per month. That too irregularly, my lord. So, my lord, the case is, my lord,
How you are appointed?
my lord, we were appointed, my lord, on master roll basis, my lord. Lordship will see the appointment orders,
See, Mr. Datta,
my lord.
I think you will have to cross this. You file a.
I filed a reply. I filed a reply.
No, composite affidavit.
I filed a
The,
reply.
the red petition will allow you to file press, including the termination. Termination you cannot dispute now. When the authorities.
No, they have not given us.
So
termination.
employers say that you have been terminated.
That's
That too in 2023.
My lord, they have not given us any termination orders, my lord. What can we
It doesn't
challenge?
make a difference. Once you are terminated, terminated.
Lordship, my lord, Lordship has seen the Supreme
That
Court.
that may be a good ground to challenge it.
I understand, but the Supreme Court has said, my lord, that this kind of termination orders, my lord, are, my lord, totally
That you are
deprecated.
not
My
challenge. That's what I'm saying.
lord, these people,
See,
my lord,
what I'm suggesting is, I'm not compelling you.
My lord.
Compel you. Not compelling you. See, wrongly or rightly, may have correctly or incorrectly.
my lord,
They said that it has been terminated.
my lord.
You withdraw this petition,
My
will
lord.
give you a liberty along with to raise the challenge the termination,
My lord,
right? Including the issues, the grievances you have raised,
my lord. No, I-
barriers or whatever, or the regularization. Unless that is done, it will be difficult.
I'll be taking instructions because these people, my lord, they will not, they will
Hey, you
be.
take instructions, it's
They-
better, so that
if-
we can, consider entire matter, because simply filing I understand, without, this cannot be just simply saying that they have done it, not to do.
My lord.
But for that, we need to.
No, I understand what is following from Lordship. I
Yes.
fully appreciate that, understand that, my lord. So, my
But
lord,
then, in that case, you take
Lordship,
instruction.
that Lordship
It
taking
means
instruction.
That they don't want to, pursue so far as the termination is concerned or discontinuation is concerned.
My lord.
Then we may decide the other issues,
Well,
whether
they-
you are entitled for arrears and all those things.
My lord, these people, my
Are
lord,
you admitting this thing?
Paragraph number
And
7.
your main prayer is for providing a minimum scale of pay.
yes, that was.
So-
that was-
So now we cannot say no now. When you're discontinued.
No, I understand that.
Challenge
I
that
understand,
also.
but the Supreme Court has said, my lord, when the litigations are pending, this kind of discontinuation is deprecated.
That's why this
In
is
my lord,
a
in my lord, Sripal, my lord,
grant for you to have.
I understand what is going on.
Unless you raise that, and simply
No.
because you file a affidavit denying will not do. There's at least. there
Maybe
must be-
I'll file another writ petition, allow me to take with this, that will be what possible.
Yes.
Let's see what can be done with it, because otherwise it will again be, my lord, a long run affair, because from 2020, my lord, this petition is pending. And they were being paid, my lord, 2,000 rupees, that too irregularly, my lord. They've admitted that, my lord, there are, my lord, dues, my lord, pending.
No, you
on-
take instruction is
Right.
better.
Well, I'll take instructions. my lord.
Not Mr. And Mr. M, but then counsel for the petitioner. Submits that he may be granted some time to take alternate instruction in view of the fact that the responding authorities filing the affidavit has stated that the services of the petitioners have been discontinued way back in 2023. All of them,
Yes.
2023. That's all.
Though we have denied, my lord, we'll file it.
Huh?
Though we have denied that in an affidavit, but then,
But
yes,
it's up
since
to
the
you.
lordship
You
said,
take
my lord, yes,
instruction, huh?
yes, sir.
To the respondents. Standing council,
Yes, your lordship, for water resource.
Water Resource Department.
Yes.
is present, huh? Next,
Obliged.
Obliged, your lordship.
after 3 weeks,
3 weeks, 3, my bad.
just a matter. So you just said that by where in the law? Is that this one?
May this lordship. My lord, here the petitioner is praying for his seniority as per the merit list which has been prepared on the basis of recruitment proceedings.
Hmm.
And also to correct his pay as per the merit list.
When you were finally appointed?
I was appointed in the year 2016.
Hmm.
However, the advertisement is 2009 advertisement. My lord, what happened here is that the petitioner participated in the recruitment process for the post of Constable Chitty. However, though he was qualified in all the physical days and all the days, he was unfit. He was found unfit in the.
What is the order of this court?
My lord, it is a third
you are-
litigation. The first litigation order is Annex 1, my lord. Annex 1, page 11, page 17. The relevant portion is page 18, my lord. The first litigation was disposed of with the direction to consider the case of the petitioner against normal wastage vacancy,
First order.
my lord, page 18.
Petitioner has accepted the above position. The respondent counter they have taken the plea that the last general category having security and has not committed to the but he could not accommodate the fact that there are many candidates according to already there.
And
Yes,
thereafter,
that should have been considered against the normal waste vacancies.
my lord,
In the year there was about 61 normal waste vacancies. This fact is implied in the description by the response. But the SMS that is not aware of present may examine the feasibility or otherwise the control is a case of normal waste. Yes, then
yes, however, on 5/2/2015, the respondent refused to select the petitioner, stating that,
after the court's order,
yes, my lord.
then
Thereafter, we have challenged the court order passed in 5/2/2015, challenging in with the,
selected can
yes, my lord. The second round of litigation order will find in page 24, Annex 2.
Yes, then
Yes, my lord, this second round of litigation was disposed of with the direction to
offer
treat the petitioner as a selected candidate against the normal wastage vacancy under general category and thereafter offer him consequential appointment. This is the order passed by this honorable court.
then you are appointed
Thereafter, I was appointed by order that,
2016.
yes, my lord. However, my seniority has not been granted, and moreover, I'm getting less pay.
Who is the respondent?
Actually, my friend, Mr. UK Kusami, CAC, he's here, Your Worship.
Hmm.
He's on Lakes staff at court number 7. So he informed me to inform the court about the matter. And so, Worship, can you take up the matter if after some time, if possible, Worship? Because the engaged counsel is court number 7. There's a matter going on of him. It answer, no? See, yes.
Well, yes. Yes.
And this is the facts of the case of this approaching this honorable court.
Yes, your appointment is of 2016
16. However,
on the direction and intervention of
Yes.
this court.
my lord, here what happened is that petitioner was found fit after a review medical court. The petitioner appealed for the review medical court, and thereafter he was found fit. However, the respondent, they have denied this particular result of finding him fit, and they have rejected my appointment, and even though there was in court direction.
Where is the seniority list?
Well, here I have not annexed here, but
Then-
however,
Now you can challenge that seniority
well,
list.
well, my juniors who were or page mate who were appointed on it in person to the advertisement
How do you know?
2009.
How do we do know? How do we know? Suppose today we allow
My lord.
that your appointment should be from the date of appointment of selection or whatever of your colleagues, then you will be placed above all those persons who will be affected.
My lord, but my merit list cannot be ignored at the same time. When I score
Where
for
is the
teaching
seniority list? Who would be affected in case your writ petition is allowed?
No, I may be allowed sometime. I'll bring in the court of.
Area financial benefits to it not possible. Because you have not worked.
My lord, the
You have
delay.
you have joined after 2016.
My lord, the delay of my appointment is not on my fault. It was on the fault of the respondent for
I
issuing me.
understand, but it's
my lord.
difficult. Areas financial benefits to.
Though there was court direction of me being appointed.
Yes, sir, what is your?
Oh, in fact, Mala, in this matter, we file our counter.
Ah,
In our counter, we clarify, but here is a case where the petitioner is allowed to join pursuant to several litigation and direction passed by this honorable court. And against the wastage vacancy, he was directed to appoint, accordingly, we appoint him on in the year 2016, that is 2011, 2016.
Hmm.
Malad, in fact, Malad, accordingly he joined. So here there is a service rule govern the holiday field, CRPF service rule. As per rule 585 of the CRPF rules 1955, Malad seniority he is not entitled because it will be a rule. Malad, it is very specific. Malad, he is on entitled only the seniority from the date of joining to the post, Malad. So the question,
response are directed to treat the petitioner as a selected candidate against the normal wastage vacancy under general and thereafter offer him consequential appointment.
Malad, against the wastage vacancy subsequent to pursuant to dishonorable
So
court
you need
order,
you
he
need
was
to-
appointed,
see,
he was
you-
appointed.
Sir, you need to reconsider
Malad.
because he should be treated as a selected candidate against the normal wastage.
Malad.
Therefore, those candidates
Malo,
who have been appointed,
malo,
you have appointed around 29.
malo.
29 having the similar, I mean, similar marks
Malo,
of 43, you have appointed 29.
malo.
Accordingly, it should be treated, the petitioner should be treated as an appointee or selection as that of 29 candidates.
Malo, Your
Then
Lordship,
you work it out.
pursuant to this honorable court's direction in 2015, he was allowed to join in 2016.
It's okay.
So accordingly,
So,
he joined in
When
16.
the court says,
Malo, seniority position will be same, Malo.
Huh?
He is entitled to get seniority from the date of joining, Malo. That is the rule, Malo.
that is the normal rule.
Malo,
Here is a case, there is a direction. He was selected
malo,
in the year 2010.
malo.
Sir, you have appointed, forget about the others. Regular, I mean, those who have been appointed
Malo.
on their categories. But wastage vacancies, out of something 65,
Malo.
wastage vacancies, you have appointed 29
Malo,
vacancies without disclosing the marks obtained by them.
malo.
In that context, court has directed to treat the petitioner as a selected candidate against the normal wastage vacancies.
Malo.
So you have to put him. He may not entitle for these financial benefits, but so
No.
far as the seniority, at least some
No,
benefits can be granted.
There is
But the
a,
court has held that it
There-
was not wrongly he has been denied.
we are handicapped in this sense because there is a service rule govern in this
See, when
Ma-
it is
position, Malo.
the intervention of the court,
Malo.
saying that you treat them as per with the persons who have been appointed,
Malo,
that too, you have not disclosed, court has recorded,
malo,
you have not disclosed the marks of those candidates who have
Oh.
been appointed, particularly 29 candidates.
malo.
So you consider it
But,
in view of this.
Your Lordship
the-
may pass order, but before passing the order, Malo, the stand taken by the, in this affidavit, that
Obviously, as per the rules,
may we consider,
the seniority shall be counted from the date of joining.
Malo,
That will record. What you have said so.
Malo, in our affidavit, Malo,
What is this additional affidavit?
Additional affidavit, I have bring in record those affidavit which they have filed in the earlier run of the litigations,
Hmm.
where they have brought in record regarding the vacancies of normal wasted vacancy,
Hmm?
which they have mentioned in the affidavit in affidavit which they have filed in the earlier run of the litigation. And as well as I have bring in record those circular notice of the respondent authorities where they have, if your lordship finds in page number 67 and excerpt 3 of my additional affidavit, your lordship will find the bracket number O,
Page 50? 50.
67, my lord,
Hmm,
67. The relevant portion is 68, my lord,
58.
68. 68. Bracket number O.
Guidelines for recruitment constable.
My lord. Here in bracket number O, lordship will find
It will catch it for
Sec-
impression on. They are finally declared it until it is further level, if any unfit case. What is the relevancy now?
my lord, one, here they have not recruited me in that particular vacancy. However, it is to be considered my appointment should be in the pursuant to that advertisement of 2009.
How?
Because, my lord, here this,
Candidate is subsequently declared fit after
If-
appeal to the
if a-
AIJ and conduct of review medical, then he has to be recruited against normal wastage of in the respective sector.
due to my delay appointment in the year of 2016, I lost my seniority.
Hmm.
If they could have followed this circular, which is it's year circular, I would have not be losing my seniority and I would be having my same fixed, I would be having the same day which my batchmates are having entitled.
Hmm.
This is the circular that, it is a circular notice which they have. However, they have not followed this. And because of this ignorance of this circular notice, I'm suffering now, losing my seniority as well as losing the pay as well. Pay
But
as well.
you should also remember that because of intervention of the court only you have been appointed.
My lord, and thereafter there is a specific direction from the honorable court who consider me. However, they have not considered me. The delay of my appointment is not on my part. So my appointment, my seniority and the pay scale should be as per the advertisement, in person of the advertisement of 2009, where my batchmates were appointed in the year 2010.
Okay, yes, your affidavit is,
My lord, the affidavit,
paragraph
paragraph 14, my lord,
huh?
paragraph 14, page, my lord. Running page,
Paragraph 12,
14, my lord.
okay,
That with regard to paragraph 14 of the,
okay. Denying the consideration listed, the petitioner has been given offer of appointment so and so, as per rule 8 of so and so, it is clear with no immediate. Those recruited is constable to take seniority from the date of their first appointment. On conversion, they will take their seniority in accordance with the date of their confirmation. That's all.
well,
This is normal circumstances.
normal circumstances, he joined in 31/1,
Yes,
2007.
it's normal circumstances.
Null.
All right.
And
That's all.
My lord, I would like to place some citation, my lord, where seniority cannot be lost on the basis on the fault of the respondent.
Yes, give us the.
My lord,
Ah. How many judgment?
my lord, I have
1 or 2?
3, my lord, as of now.
Huh?
As of now, I'm placing 3.
And thereafter, how many?
My lord, in the first Bhagwan Singh, my lord,
Hmm.
I'm referring para number 8, my lord. This is where also the prayer is seniority, and then
what is the citation? Is there any citation?
para 8 and 9, my lord, I'm referring.
Then
Bishop, my lord, the next is it's a representation of our Honorable High Court, my lord. I'm referring to prayer number 6, my lord.
then
6 and 7, my lord. The reason for which petitioner was denied appointment have, here the petitioner appointment has been here the petitioner, his seniority has been placed below those below the respondent, my lord, here. And then the petitioner has challenged this petition in this case.
para
Para number 6, my lord, 6 and 7, my lord.
having considered the position matter. Problem is that if you are saying that you should be placed above some of the.
My lord, here what the respond in my case here, it is present case, what do you do my delay appointment, I'm losing my seniority. And as your lordship sees those orders which have been passed by our honorable court in the earlier notification. The specific direction was to you give me appointment to select me as per the normal vacancy.
Then next,
My love, next paragraph next citation I'm relying on paragraph number 25 and 6, 25, paragraph number 18, 25 and 26, my lord, as well as 27.
18,
18,
then
18, 25 to 27. Whether seniority is to be counted as per the merit list. This is the citation which I'm referring now. And not as per the appointment. Because appointment may be delayed due to some technical issues or due to some other reasons, which is under the control of the petitioners.
you have not brought on record. Where is the seniority list? And how, where you have been placed, whether you have been above or below, and against whom you are claiming above. It's difficult.
My lord, I may be allowed sometime. I'll bring in report. Or else, like, my lord, I have no instruction as of now regarding the seniority list. But however,
Because that will be affected. Suppose if we allow your writ petition, they will be affected.
no, my lord, because if your lordship sees those, it's reflected in the order itself. Like I have scored 43 marks, and they have considered only those people who have age
Scored
higher in the
So
age.
less marks than you.
No, the last candidate who got appointment during my time, the marks was 43 marks, and I was rejected because of my unfit medical issues. However, as per the rules, I have applied for the medical appeal, and I was found fit. Therefore, they could not just jump into another way and then denying my appointment.
See, I have understood.
Because there's a rules.
Madam, I have understood that, but problem is, suppose in case your writ petition allowed, there may be some persons in the seniority list which you have not brought in, right? They'll be affected. In case, we have not decided as yet, in case your writ petition is allowed, they'll be affected. There will be persons affected, and they are not party before us, before this court.
Or my seniority can be counted from the particular list where where the similars whoever scored similar marks.
Where is the selection list is there?
But I have the advertisement. I have index.
Not advertisement.
Selection
any
list, my lord, I
selection
have
list?
in next year,
This is the whole
my
problem.
lord.
There's no selection list. We'll take it up on Thursday. You think about it.
My lord.
We'll keep it part hard.
Mal.
Take it up on Thursday. Think about it.
My lord.
I've indicated. Isn't it?
Well, definitely they have not made
Oh,
party to
in
the
fact-
them, at the
In fact,
villages.
those,
they cannot-
selection lists and all those will be in record of the respondent, who may also help the work in bringing in recorders.
Or else we'll advise direct you to consider. If it is
As the
permit-
look,
in accordance with law.
Your honor, please, Malad, your lordship think it proper, but I indicated that provision may be quoted so that.
No, provision though, it's upon normal circumstances.
Malad.
There is no dispute to that.
Here, what happened medically, initially,
Immediately
he was
from
not
the date
paid,
of,
subsequently, Malad,
Either from the date of appointment or from the date of confirmation.
Malad,
It's the rule.
Malad, that is the rule.
There's no dispute to
Malad,
that.
Malad.
It's a different circumstances.
But seniority, Malad, from similar situation, but they had not paid party, this is a 2022 writ petition, Malad, at this belated state at the final disposal time, Malad, there.
On Thursday,
That
we'll
cannot
take
be,
it up.
Malad.
Take it up. All right. Hard MS. Ah,
Iwa Pangla.
Iwa Pangla. Learned counsel for the. This is? Your name is not there.
My lord, mine is not there.
Huh?
My name is not there.
You signed the wakaltnama.
My lord, not, I have not filed.
You'll have to. It cannot be partnered also. You sign the wakalatnama, you file your power, then we'll hear you. Then Monday. All right. It would not be proper. Because tomorrow is a reason also. Tomorrow, if your writ petition is dismissed, blame will go to you. That crime petitioner will say that I have not given a power to her. Right? If it is allowed, it's okay, he may not. But otherwise, right?
My lord.
So in that case, after 1 week, will not
After 1
keep
week?
it part hard.
Yes,
Mal.
my lord.
I didn't realize that. I mean, lawyer,
Malad.
you should not have that kind of. All right. You get the power and file it. All right. Not MS Wapangla, Learned Counsel, T. Wapangla,
My lord.
who appears for the petitioner, and also Mr. So and so. Mr. UK Goswami,
Malad,
you are CGC,
Malad.
and the CGC for the respondents on the prayer of Mr. MS Wapangla. Let this matter be listed after a week.
Okay.
So can this matter be taken up after 2 weeks or so?
Why? Okay. On the prayer, Mr. N. Gautam, then counsel for the petitioner, and the prayer not being objected to by Mr.
And not.
And not, then counsel for respondent 1 to 4.
1 to 4.
1 to 4.
This
Two respondents.
1 to 4 is what?
State university also.
Huh?
University.
Krishnakanta Pandikoy State Open University.
KK Open
University. This matter after 2 weeks.
May I please, Your Lordship?
Yes,
My lord, you also kindly take up item number 18 first, please.
18.
18, my lord.
What is the matter?
My lord, here, my lord, I have challenged the de novo inquiry.
De novo inquiry.
Yes, please.
You are serving as?
Inspector of police, my lord, Assam police.
What is the status of inquiry? There is a stay?
There is a stay, my lord.
Ah,
Now, Your Lordship, kindly say the impugned order.
Who is the
NH
respondent?
My Lord, the government.
Item 18. This is 17, right? 18, give me the 18. Give me the 18. Oh, okay, it's here. 481,
Yes, my Lord.
4819.
Yes, my Lord, 481.
Just see, let us see, page.
Page 21 NH B, my Lord.
Why, what is item 17?
My Lord, he was suspended, that was challenged.
Suspension.
Yes, my Lord.
Still you are under suspension.
Still I am under suspension. In the year 2023, I was suspended. Then inquiry was initiated and the guilty was. Page 21 NH B.
20?
21. The last para is important, my Lord.
Let us see, different procedure drawn up against so and so, so and so, on this charges of gross misconduct, dereliction of duty, and you were arrested in connection, so and so. Yes, so called notices, will be given inspector, so and so. Inspector of police has submitted reply. The inquiry officer in written. Yes, presenting of key, presenting first. Yes, what's the wrong?
Your Lordship, can you see the last para? The disciplinary authority perused the finding and found not to be.
I have read it. De novo.
Yes, ma'am.
They are
De
not
novo.
satisfied.
Inquiry.
Yes, madam. Now the question is whether de novo inquiry is permissible or not. It is not permissible.
How?
Your Lordship, can you see the provision, Miller? It is not permissible.
Where is the provision?
There is no exclusive power vested to the disciplinary authority to initiate fresh inquiry unless there is any material irregularity. Unless there is any material irregularity. Your Lordship, kindly see point 6.18.1.
What is this?
The manual of departmental proceeding, Miller. It is written there.
Passed by inquiry officer pursuant to de novo inquiry, the same shall be subject to outcome of this. Where is the stay?
My Lord, there is an order passed on 15/9/2000.
29.
15/9.
20.
15/9.
It says any order passed by the inquiry officer pursuant to de novo inquiry, the same shall be subject to outcome of the petition.
No. Thereafter, another order was passed on 15/9/2025.
15/9.
Yes, sir.
In which case?
In 4819.
There is no order. There are only two orders.
No, there are so many orders. Miller.
There are only two orders. In 4819.
Well, both the orders, Miller, was clubbed together. Miller. First 1519, then Miller 4819.
By whom?
It's a common order passed. Miller.
And then probably should they accept to cure the material defect that they have. Yeah. It's not here, it's in other matter.
Well,
Common order, maybe common order.
common order. Miller. Considering the judgment, my lord, I have submitted on the basis of that, my lord, this order was passed.
No adverse order, but the inquiry is, as such has not been
Milord,
stayed.
no adverse order, that was correct.
No, inquiry has as such not been stayed. Proceeding has not been
State
stayed,
Milord, yes, Milord.
only.
No outcome
adverse
has
order.
come, that's why record was called for Milord. And your lordship kindly said
You
that.
have the records.
Record, I have a record, lordship, and the inquiry report is also here.
Hmm.
Which basically at the end of the inquiry report, lordship, it has been stated at page number 105 that the then inquiry officer, he was not satisfied with the the evidence as per, there's no evidence and material to hold him guilty. That is the thing, that the department was not satisfied. Accordingly, the de novo, that is the only.
No, that's not only that. What he is saying is that there must be the de novo is to be on the basis of to cure this thing.
Material mistake.
Yes.
Lordship, that we have, lordship, supported in the parrot number 10 of the affidavit, lordship.
I'm sorry, only to rectify the material defect.
Material, yes,
Just simply that you are not satisfied the inquiry of.
that have come through, lordship, that is there, but lordship may kindly say para number 10 of the affidavit in opposition. It is something that how we can do it.
Where it is.
Page number 29.
Which
that-
case?
Affidavit.
The same case, 1590.
They are affidavit in opposition.
Page.
Page number 29. That para number 10. Which reason the deponent begs to state that the disciplining authority filed an order.
29?
Page number 29, para number 10.
Page 29, affidavit.
Page
Affidavit in
29.
opposition.
It's a
Which
running
matter?
1590, left, sir. Ajay Kumar Hendik.
No, 4819. 4819. This is 4819.
Ah, 1590 to release question.
তাতে raise করা আছে।
It has come, lordship, the two matters have come as with the first one, lordship, 1590.
Not in 1590.
No, yes, so I'm sorry, lordship, 4819 we have filed the affidavit. I'm sorry. Because it has been inserted in the first file. That's why.
Yes,
4819,
para 10.
yeah, para 10, lordship.
Hmm.
The deponent begs to state that the disciplining authority filed an order dated 6/9/24 set aside the funding dated 22/8/24 submitted by the inquiry officer and ordered for a fresh inquiry into the charges against the petitioner by appointing a new inquiry officer. The deponent most humbly begs to state that the disciplining authority is empowered under the provision of para 6.18.1 of the Manual of Departmental Proceeding either to set aside the whole inquiry and start a fresh inquiry de novo or to set aside the inquiry from the stage of occurrence of irregularity or an order to start afresh from that particular stage. The provision of para 6.18.1 of the Manual of Departmental Proceeding is report is herein below. The disciplining authority on a contention raised by the person proceeded against or otherwise finds that any material irregularities have been committed that they have caused or they may have caused prejudice to the person charged or such irregularities are likely to vitiate the proceeding, it will consider whether the whole inquiry should be set aside and the fresh inquiry started de novo. Point number 2, whether the inquiry be set aside from the stage of occurrence or the irregularity and it be ordered to be started afresh from that particular stage. It is pertinent to mention here that there is no requirement of serving so that is true for the second time except where the whole inquiry is set aside and the fresh inquiry started de novo. In the present case of the petition, the disciplining authority has set aside the funding of the inquiry and directed to conduct the inquiry into the charges afresh de novo by appointing a new inquiry officer as per the provision of 6.18.1 clause 2 of the Manual of Department Proceeding. So basically, this is the point, lordship. Other than there is any material mistake, we can also proceed by that way. Lordship, in that point, lordship, today, lordship, I'm being limited with some of the good judgments of the Supreme Court, lordship. So maybe, lordship, I may be allowed to produce some of the judgment on a very recent date fixed by your lordship. If Lordship allow, so because Lordship otherwise only based on this record and affidavit, it will be difficult because he is adding two or three as well.
My lord, on 15/9/2025, they have said the same thing, my lord.
No,
There is an order, court recorded.
Not Mr. So-and-so, learned counsel for the petitioner. Mr.
I Rafiq.
Huh?
I Rafiq.
I, Rafiq, learned counsel for the petitioner. Matter is. No, after hearing the matter at some length, Mr.
CKS Borwa.
K.S. Barwa, learned standing counsel.
No, government advocate asan, yes.
And state council submits that he may be granted some time to place some judgment in the matter. Considering the, not considering. Let the matter be listed for further consideration. After 2 weeks. 2 weeks.
Yes, only date may be fixed.
Yes, the visitor has agreed to by then also. That's the matter on hearing that.
Yes, Lordship.
Now 27 were fixed so many thereafter.
2 December.
Two also were thereafter
4 December, Lordship.
hearing day.
4 December.
4th December. Is it Potter?
Muscle.
Potter, huh?
Yes, Lordship.
Lord, this pertains to denial of the third MSFP benefit to this particular petitioner. For him to be counted for the third MSFP upon completion of 30 years of service, which is a financial benefit. The rules require that my ACR should be graded high average, that is 7 marks. Sorry, very good. But then my ACR for 2022 was rated as good only. Then when my MSFP was not granted, my lord, I made a prayer before the respondents that as to why it has not been granted. Then I get to know that, my lord, my 2022 ACR was rated as good and not very good. Now, my lord, since it is a uncommunicated entry, my lord, I filed this particular petition saying that as per the subtle law, as far as, my lord, grant of financial benefit is concerned, those entries are actually to be expunged, my lord. In case of promotion, of course, it's a different thing because third-party rights are also involved. It's only a case of financial benefit. I enclose the cover judgment of this honorable court also at page 33, my lord, and Annex 5. Similar circumstances, my lord, exactly. The respondents affidavit, my lord, they say that no, we had communicated the entry and they, my lord, filed. If your lordship takes up their affidavit, at page 80. Page 80, my lord, is part of the ACR.
Page
80, my lord, of the affidavit of the respondents. Towards the bottom, my lord, signature of Reti after showing entry of apart. My lord, my case thereafter is that, my lord, is that being shown and being communicated are two different things, my lord. I have to be given a copy in order to represent because this is what is the mandate of the rule, my lord. If your lordship comes back to my writ petition where I have given the entire my lord, picture. Page 23 is the relevant, my lord, instruction and circular which governs communication and maintaining.
Sir, are you ready?
records.
Yes, yes,
My lord,
Okay.
very short issue. Just, my lord, I'll just point out two things only.
Hmm.
As per clause 37 at page 23, my lord,
Hmm.
the APR are to be initiated in duplicate. Accepting authority after endorsement will return the APR to the reviewing officer for communication of the entries to the ratee. The reviewing officer will ensure communication of the APR of the ratee and will obtain his and her signature as acknowledgement as per Appendix F. So F is the format, my lord, in which the copy is given, and, my lord, the signature is obtained. That Appendix, my lord, F is at page 32. Page 32, it says, my lord, this is the format, my lord. This is the procedure they have to follow. It is certified that
For communication.
my lord, acknowledgement annexer Appendix F, page 32, my lord. It is certified that the photocopy of annual performance assessment report for the period from so and so has been served on me, and I have acknowledged the same, please. So the communication, my lord, as per their own policy, contemplates a photocopy is to be given to me, and only when I get this photocopy and as per Appendix F, I can thereafter, my lord, represent. What they have said that is a communication is basically that their own language says that it was only shown to me, not communicated as per Appendix F, as per the rules, my lord. That is my simple case, my lord.
Yes.
Yes,
Otherwise, uncomplicated entry or remarks cannot be
My lord,
acted upon.
cannot be acted upon, particularly when it's financial benefit only, not promotion, my lord.
well, I have to go by the materials available on record.
Yes.
And as per the affidavit, yes, so that document which is annexed in the part of the APR, it is shown to
Only
him.
shown only.
And it is shown to him, but
Not been furnished. Copy is
his
not been
knowledge is
furnished.
there, yes, his knowledge is there, but it's obvious that regarding that page 32, that annexure, the form and acknowledge, that is that is not.
Very
available.
fair. Thank you. That's
I have
all.
to go by the record.
Yes, yes. That's all.
And because if it is there, they might have, deponent might have annexed it. So it is not annexed, not provided to me.
We'll go by the coordinate bench.
My lord,
My lord.
But
Annex of five, my lord,
my
page
submission will be, my lord, it is whatever in the affidavit, my lord, it is shown to him as per the affair, his signature is there, that
It's amounts to communication.
yes,
My lord.
We'll record that.
My lord.
my lord.
Whether shown amounts to actually
Ah.
communicate.
My lord, that is, my lord, it is,
Okay,
his
yes.
knowledge, his knowledge is there, my lord.
Heard Mr. V. Pathak, learned counsel by the petition, and also heard Mr.
K.K. Parasar,
A.K. Parasar, learned CJC.
my lord.
Correspondence by filing this writ petition. The writ petition as fed for it. No, no, direction to the responding authorities to consider consider for providing the benefit of MSCP -3 commentary on completion of 30 years of service with effect from 06/07/2022 by expunging any uncommunicated adverse entry in its APR. The petitioner has also fled for revision of the pay and allowances after granting the MSCP 3 with effect from 007. 06/07/2022.
My lord,
I'll pass in the chamber.
my lord, my lord. Annex
Continue.
5, page 32, my lord, is the
Ah,
coordinate
yes.
bench order.
2-3 page, we'll just record this statement. We'll go by the same this.
Right.
Devdutt.
Devdutt?
Devdutt.
Right.
Principal is Devdutt.
Devdutt.
But that is basically for promotion,
Hi, my lord,
is not it?
my lord. Devdutt and Shukdev, my lord, both are cited here
Shukdev.
in the coordinate bench order.
CKS.